Any letters we've received in support or opposition to a case. At the conclusion of our presentation, the applicant will come to the table here first and present their testimony along with any persons in support of their case. If there's opposition to a case, the board will then hear from those parties opposed, and then after the opposition speaks, the applicant will have a period for rebuttal. Again, a reminder, a rebuttal period is only to cover the issues raised by the opposition and not to provide new testimony, okay? The board in their rules provide cases without opposition 10 minutes to present their testimony. To the right of where you'll be sitting is a clock. Your time will start once you introduce yourself. We'll stop for any questions that the board might have for you. In cases with opposition, each side of a case has 15 minutes to present their testimony. So the opposition in total will have 15 minutes, and the applicant in total will have 15 minutes. Please divide your time between speakers, if you have multiple speakers, to divide that 15 minutes up. If the applicant wishes a period for rebuttal, they will need to reserve some of that 15 minutes for their rebuttal time. All section numbers that I refer to today come directly from the Metropolitan Code of Law in Title 17. It applies to the entire jurisdiction of Metro government, and Title 17 was adopted by the Council and became effective January 1st, 1998. I'll introduce and make a part of the record the zoning code, a copy of which is at my desk, and I'll dispense from reading individual sections unless someone wishes that I do read those sections. The zoning code requires that these proceedings be taped. Therefore, it's imperative anyone wishing to address the board to come forward. On the stand there, just like my microphone stand, is a speak button. When you do that, the ring will become red. Your mic's hot. Go ahead and identify yourself and make your presentation. When you get done, if you would, please turn that. You notice the light goes out from around the ring. It should be noted that if anyone's presented false or misleading testimony to this board that may have affected the board's decision, any approval may be revoked at a later date by means of a show cause hearing. The board will go through all cases set for public hearing today, and after each case, the board will then discuss and vote on that case. The board's vested with the power to act before us today under Section 1740-180 of the Metro Code of Law. The code requires that 4 members of this 7-member board be present to constitute a quorum. The code requires that you have 4 affirmative votes to grant your application. Currently, I have 4 members before you, so you need all 4 members' votes for your case to become approval. I am expecting a 5th member to arrive here in just a moment. In the event that we only have 4 members hear your case, you need all 4 votes, and if you fail to get those today, your case will automatically be reset for a new public hearing at the next available date. Currently, that date, Ms. Huey, is March the 21st is when you would be scheduled for. Nothing further is to be done on your part. Our office will handle the renoticing and refiling and placement of new signs on the property. No additional fees are required of you. Your case will come back at that later date. It will be a brand new case, and then depend on the numbers present. You'll need 4 of those members, 4 votes of that board at that time. In the event that we have 5 members hear your case, you need 4 affirmative votes still to grant your application. In the event that you don't get 4 on a case with 5 or more members that heard your case is tied up on votes, and what that means, the case will stay on our agenda for the next 30 days. Those members that participated can change their vote. Members who were not present can watch the record and become eligible to participate in the case and then vote at that next hearing. If after 30 days no one changes their vote and you still do not acquire the 4th vote, your case is deemed denied by operation of law. The appellant or any aggrieved property owner may request a rehearing within 60 days of today's public hearing. Further, any applicant or aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within that same 60-day period. But once that 60 days has elapsed, the board's decision is final and no further action may be taken. If you're an applicant and your case is granted, it is necessary for you to come and pick up the permit for which you've applied at the codes office. You can begin processing those permits on Monday morning. It should be noted you have 2 years from today's date if you gain approval to pick up your permit. And if you pick up that permit within the 2 years, your case is vested for good. If you fail to pick up your permit within 2 years, you must come back and seek this board's approval for your request. Mr. Chairman, I submit that all cases were filed in proper order. Appellants were notified by certified mail as required by the code. All affected property owners have been notified, and a legal ad was published in the Tennessean as required by the code. And before we begin, let me see if I have any preliminary announcements. I do have one, and I apologize for the order listed on the docket. The first case on our agenda would be cases 11 and 12 at the top of page 2. The board heard those cases at the last meeting and would consider those cases first. They agreed to do so at the last meeting, since I believe they were at the end of the last agenda. And so we'll hear those cases first. When we get to them, case 10, if we hear that, will run down just below case 12. And so we'll begin that. The board does have a consent agenda, and I'm getting a little ahead of myself. Sorry. The board does allow elected officials present, should they wish to address the board, can come here if they wish to. Councilman Davis, I'm sorry. I just totally ran past your face there in the crowd. So, are there any other elected officials beside the councilman who'd wish to address the board? Okay. The floor is yours, sir.
Thank you, sir. I just wanted to speak briefly on the Cahal property. Is it case 13 or 11, 12? I'm sorry. Just before you guys get into the regular agenda. I'm in support of this setback variance. It's a very awkward lot over there in Inglewood on Cahal, and I think what they're doing with the setback variance, moving the two homes to the front, I'm fine with that. And then there's maybe a plan for further development later. That part, we've still got work to do, I feel, with neighbors. We'll be meeting with the neighborhood group, and I think there's some opposition to the setback just because maybe it concern for the ripple effect. But I just wanted to assure Inglewood and other neighbors that again, I'm okay with this. The majority of responses I've gotten at the last neighborhood meeting, I think everyone feels okay with this. They just want to know what's going to happen with the property later. So, this being a necessary step to further develop the property and make it more of a standard, fitting in on Cahal kind of property, I think will be fine. So again, perfectly okay with this initial step, and then we're going to be talking further and hashing out with the neighborhood kind of what's happening next. So just wanted to express my support. Questions?
Thank you, Councilman. Any questions?
No questions for the councilman. We'll proceed with the consent agenda. The board does have a consent agenda, and prior to today's meeting, a board member reviews the record in the case, on each case prior to the hearing, and if in their opinion the applicant meets the criteria for which they've requested and they feel that testimony would not alter the material facts, they recommend the case to the remainder of the board for approval. I'm going to now call out the cases that have been recommended by the chairman, Mr. Whitson, for a consent agenda. If you're here in opposition to one of these case numbers that I call next, please raise your hand. Make sure I see you, and then we'll hear that case in its regular order. The first case recommended for consent agenda is on the first page, case 2013-10, Reyes Construction, the appellant, H.F. Baker, Jr., owner of the property at 2310 Antioch Pike, requesting a special exception to construct a 120 by 300 foot indoor soccer facility and 2 outdoor fields. Is there anyone here in opposition to case 2013-10 on Antioch Pike? Antioch Pike, case 10. Mr. Chairman, seeing none. This is a special exception request. It's actually a modification to an already approved plan by this board for outdoor soccer fields. They're wishing to create an indoor facility as additional to 2 outdoor soccer fields. They are agreeing to put in all the necessary requirements of the code, and it meets all the requirements of a special exception, and Mr. Whitson recommends that case to the remainder of the board for approval. The next case recommended for consent is case 2013-13 at the top of page 3. Mr. Herman Jeanette, the appellant owner of the property at 5971 Port Andarco Trail, requesting a variance in height provisions in RS-15 to construct a 16 by 24 detached accessory building behind the house. Is there anyone here in opposition to case 13 on Port Andarco Trail? Case 13. Mr. Chairman, seeing none, the exceptional topography and floodplain on this property necessitates the need for a variance. The gentleman in the May 2010 floods property was severely flooded, and his additional height, he's proposing to be able to let him store items in the second floor should there be a recurrence of flood in the future. The next case recommended for the consent agenda is case 2013-14, Metropolitan Government at 5050 Blue Hole Road, requesting a special exception in the AR2A district to construct 3 additions to Antioch Middle School. Is there anyone here in opposition to the request at case 14 on Blue Hole Road at Antioch Middle? Mr. Chairman, seeing none, call again. Case 14. No opposition present. This is a special exception to construct 3 additions to the existing Antioch Middle School, rework the entire parking layout on the site, and bring the parents who would be picking up at Antioch Middle off of Blue Hole Road. Currently, traffic stacks on Blue Hole to pick up. They would change the circulation of that to get those cars off the street. Will be a vast improvement to that situation. And then finally, the final case recommended for the consent agenda is at the top of page 4, last page, 2013-016, Mr. Robert Thompson at 4334 Old Hickory Boulevard, requesting an item D, which is a change of nonconforming use to allow the property to be used for personal care services. Is there any opposition present to case 16 on Old Hickory Boulevard? Sure, no problem. Is the applicant present for case 16? Would you two guys like to speak? I have, well, I thought I had a room back there. If you guys would like to talk, we'll heal that off the consent agenda to let you guys discuss the situation. And if it's something you can work out, I'll be in contact with each of y'all on that. So with that, the current consent agenda as it stands will be cases 10. Cases 13 and 14 are recommended by Mr. Whitson to the remainder of the board for consent.
Okay, so we have a motion. Do we have a second? Second. Got a motion, a second. All in favor? Any opposed? Passes.
All right. If you're here for cases 10, 13, and 14, your cases have been granted. You are free to go. And with that, or you're welcome to stay if you'd like to. Yes, sir. Yes, sir. And then those folks that have been approved beginning on Monday, you can follow up with the Codes Department about your permit. All right. And the first case we will hear today will be the 2 deferred items. These are 2 separate cases. Let me remind you, they're not one case. The board needs to handle these individually. And we'll call now the applicant in case 2013-11 at 1623 Cahal Builder Ventures LLC. The applicant's present for the case. He is present. I see him there. Any opposition present? Okay, we do have opposition present. Each side will have 15 minutes to present. While the applicant comes to the table, let me kind of recap to the board where we stand. I'm going to show on your monitors as well as up there and get us caught up to speed. Before I do that, though, we do have 2 members currently sitting with us who did not participate at the original hearing. And first, Ms. Jones, I'll ask you, have you reviewed the record in this case? And do you wish to participate in this case? Ms. Jones, the record will reflect Ms. Jones is now eligible to participate. Mr. Ewing, you as well, were you able to review the record in this case?
Yes.
Okay. And do you wish to participate in this
Yes,
case?
I do.
Okay. And with that, 5 members will hear this case now. Mr. Ewing and Ms. Jones are now eligible to participate in the case. And I'm going to get you guys caught up to where we are now, if you'll give me just one moment. Okay, the subject case and then the subsequent case that will follow are 2 adjoining parcels on Cahal Avenue at 1623 for case 11. And 1623 is requesting a variance in the street setback that would be on the center property, parcel 266, that my cursor is moving on. That request is to move this home, which you see on the lot, forward. The applicant is requesting a variance in the street setback on that lot to 30 feet. This was the prior site plan submitted by the applicant. I'm going to show you the revised plan here in just a moment. But the request was to move this structure forward. The setback is the average of the homes to either side. So in this case, we would essentially treat this as a vacant parcel, 65 feet on the right-hand side, and then your average coming out to be 30. These photos were shown at the last hearing. I did not revisit the site. I did drive by the site. Nothing on the two subject parcels has substantially changed that would affected the images there. I'm going to skip over to just a moment. The revised site plan I tagged on parcel on case 12, and we'll revert to case 12 in a moment. But or if you'd like me to, I can describe it now. But I do need actions independently of each other, please. This is the revised site plan. Again, the prior site plan from the appeal, and the revised plan showing the structure that currently sits here would be raised and moved forward as well. And then the proposed new constructions on case 11 and then case 12 there. And a view of case 12's photographs. And I can come back to these in just a moment. I would like to leave this site plan up that shows the revision. On the subject lot of case 11, what you have out there is a duplex now. You have two freestanding residential units there, single-family dwellings. By definition of the zoning code, that is considered together a duplex. That same duplex arrangement would continue to occur on case 11. This home at the rear would be raised and then brought forward as well. With that, gentlemen, is that a fair summary of where we stand today? I hope so.
The only change or clarification, if you meant raised as in raised up or raised as in demolished, it's going to be demolished in a new structure.
Yes.
Okay.
All right, gentlemen, I'll turn it over to you guys. You'll have 15 minutes. Again, please be sure to save a portion of your testimony time for rebuttal.
I'm Michael Matthews, and I was here the last meeting, and it was suggested I come back with a better plan, a more detailed plan, and this is John Goff, my engineer, and we put this together, and it shows what the current layout, what it could be, and what we would do. You want to say anything, John?
I'm John Goff with PDR Engineers. Basically, what Mike is trying to do on the site is, I think everybody said, is he wants to take the existing house and move it a little bit forward on the thing and center it a little bit better so he gets a little bit better front yard and backyard for the two facilities. He's going to demolish the existing house in the back and move it forward into the middle part of the lot, and he's going to construct the second home behind it similar to the one that he's going to move up in the front.
I was trying to figure out, will this improve the neighborhood or will it increase the neighborhood value of the property is what I was really concerned about, and I think that's what the people around there was concerned about. But with me, it could be good or bad. I'm no against or whatever. If it improves the neighborhood, I'm for it.
I think there might be some. He would probably could have spoken at the opposition or support section, but as long as he's talking good, I'm good.
I know he's looking
duly noted.
Yeah, basically.
And let's repeat again. Tell us about your interaction with the councilman and how all this came to be and what you've done since the last meeting.
We had we had one letter from the people across the street that couldn't make it, and they didn't make it back for this one either. They own 3 parcels directly across that surround the little market, and then we had some more opposition from a lady and her husband that were landlords on the street that's behind. It's a cul-de-sac behind, about some water issues from that deluge we had about a month ago. And I went right after the meeting. I went out and looked at the property. There's another the track to the one that has the mobile home on the front. They have constructed a new long rectangular house that's under construction right now. Matter of fact, it was shown in the picture. I have nothing to do with that construction, and I let's see, it's going to there it is to the right behind that pod. And so I went out there and looked, and the erosion controls in place on that property. It had its integrity was in place, and I believe the water is coming just from that unusually heavy rain we had. And but I offered to help go down a stormwater with them and help any way I can. And I actually called Kimberly Hayes down there to give her a heads up. And we stopped by there on the way over here to catch her, and she said they were working on it. I think Tom's aware of it, and they're working on it. Automatically, this site will go through a review. It's flagged to be reviewed for stormwater because of the area that it's in, because I guess the little ditch that's behind us. So there. And I asked at the last meeting to go ahead and for Joey to tag or flag it for me to be looked at over and above what normally would be required if it wasn't already. But when I found out further, it is, and we are automatically doing that.
Let me just ask a question. I mean, I end up saying this a lot, but we're a quasi-judicial board, and we are only empowered by state law to give variances if there's something unique about the property, such as topography or easements or trees or narrowness or odd shape of the lot or something like that. So we have to have a unique characteristic of this lot or lots that allow us to grant a variance. And I think where we came out last time, somebody correct me if I'm wrong, is that we had I think it was called a boarding house on the back corner of the property that's very unique because there aren't many boarding houses whatsoever, much less in the back corner. And as I remember, that was the cause for the great required setback, is that it was brought into the calculations for the setback. Somebody tell me if I'm doing wrong here, but I'm trying to figure out what the cause or what the uniqueness of the land is that is doing it. And I think we had questions on what was going to happen to that boarding house.
Well, the way it was explained to me is that that we would lose one unit out of the boarding house to be able to gain another house up in the front, and that's fine. It is what it is as far as what the ordinances require. And the unique situation to this property is that the setbacks are so far that if I am going to, when I build another house, I'd like for the areas to be comparable or equal. So and also these are two applications. So to address the one on the right next to where that new construction is, by moving that one up closer to the road, I will have a balanced both lots. They won't be lots, but they'll be recorded easements. And the front unit will have their own recorded easement, and the unit behind them will have theirs. There'll be roughly the same amount of square footage to each other, and balance it out. And then from an aesthetic standpoint, the house that's going to be in front of the boarding house, I want to match it. I'm going to match it with the architectural style as well. And for that boarding house area, I would like to have a common area in the back that would correspond with the easement line, if you will, that divides the one to the right, so it'll all be the same. Does that make sense? Or not necessarily? Yeah. Any questions on that?
I don't think you've answered the hardship question, though.
I was going to say, Chris, I guess what I'm hearing you are trying to help us focus on here is this kind of exceptional condition that the property allows. He kind of opened the door for you, and unfortunately you didn't step through it for us. So I'm going to try to help you here again, okay? What we're asking you is there a condition, because the property itself does not have an extraordinarily unusual condition like the size and shape, or there's a tree in the middle that you don't want to chop down, or something of that kind of ilk. What we're trying to understand is that there is a condition that results in you having to address this issue. And so it seems that the issue with the boarding house and the requirements of that boarding house make this property impossible to do anything different with if you move forward with this condition. Okay? Do you understand where I'm trying to take you?
Yes, ma'am.
Can you help us understand what that really looks like?
You want to go for it?
I think there's two unique conditions with the property. One, you've got the ditch along the back of it that is throwing water back on the people on the, I believe it's Jean's Court up there. If we build that house, the second house, when we raise that block building back there, and put it in that same location, we're going to have to throw a lot of the water back on that ditch back in that area, and that's going to make that situation back there in Jean's Court worse. And we really don't want to do that. What we want to do is, if we move it forward, it allows us to get all the stormwater and move it towards the front of the property and alleviate a lot of the problems they have with that area back there. And I think when we do all that and build the other property and build some kind of detention and treatment area up in there, it will improve the areas in Jean Court. Also, if you notice along that property line between the two lots, there's a bunch of unique trees in there. I've got them shown, I believe, on the site plan. If we move that house on the other lot back to where the other one is, we're going to have to take out about almost the whole tree lot through there, or at least be in the root zone of those trees, and all those are going to die. Some of those trees, while they're not unique to Nashville, some of them are probably in the 30 to 40 year old range, and the majority of them are 12 to 14 inches in diameter, and that's got a lot of appeal for those two lots. And it improves the neighborhood, quite frankly, to keep those trees in place, and for the ditch also.
Okay. So I'm hearing ditch on the right side of the property, trees on the left side of the property. Can you help, again, address the issue about this boarding house that makes this property exceptional in some way? What is the issue?
You're talking about the issue is the boarding house is on the rear property line, and therefore, because of the way you have to calculate setbacks, is unusually far compared to every other piece of property that we see from an overhead view. It skews the average in a way that's not reflective of the neighborhood or the other houses.
Well said.
That what you're...
That's where I'm going. We're trying to help you understand
so I think that's
what we have to address in order to give you consideration.
And whether we agree that that's a hardship or not, I think that is. It's
an element that needs to be.
That is the sole reason that the setback is 46 feet is because that boarding house is all the way to the back of the property, and it is unusual to have a building to calculate variance sitting on the back property line.
And probably because it was a boarding house, that's why it was set so far back off the road.
Well, actually, it was probably a barn at one time.
And then
an auto barn or a barn. I think it was built in 1920.
Well, let me ask you about the trees again. You said that you wanted to keep them, and you said they were about 20 or 30 years old. We have government older than those trees. I mean, are these really significant?
Well, it would be hard to replace a tree that big. I mean, it's not.
How many are there?
I think they're probably 50 years. They're pretty tall. They're taller than the house.
Okay, no, that looks older than 30 years.
They're older.
Yeah. They might be older than Metro.
Yeah, well, the walnut tree that's out there in front is much older than 20 or 30 years, but the hackberries and all the rest of them back in that area,
they're all pretty big back here.
They are very good size, and they would be specimen trees in other locations. So.
And you're stating that your intent is that you keep the boarding house.
I want to keep the boarding house. I bought the property to keep the boarding house.
Okay. I think the last hearing, I think you were uncertain, but your intent now is absolutely to keep the boarding house. Okay.
And I'm sorry, we talked about that setback being one of the main reasons, and I I should have reiterated it. It does skew everything. That when you do the averages, it throws it like, I don't remember. Joey did the math. It was like 95. It was a bunch, or maybe it was over 100 feet back. I don't remember, but it was significant because it skewed it so bad.
Okay.
This plan calls this a 4-unit multi to be converted to a 4-unit multi-family. Is that what the intent is for that back house back there?
Well, that might be where the confusion is. I'm weighing what my options would be. I don't know if that. I think that may be a tough. Is that supposed to be on there, John?
That was, that's one of the considerations that Mike has been making for that. He doesn't presently have any plans, I think, concrete to make that a 4-unit, but that was one of the items we were.
Are there currently,
Are
there currently residents living in the boarding house?
Right when I bought the property, he moved out. I bought it I closed on it about 3 months ago.
Okay.
There was one resident in there that, as they were selling, I think they started backing the people out of there, from what I understand.
You ask Joey, what are the stipulations on that residence back there being more than one resident in that building or whatever?
Well, it's a grandfathered use that's there now. We were able to determine in our office that boarding house is there legally. So as gentleman talked about early on, is if you construct this residence up front to maintain the density balance on that lot, to make sure you can't go out and add another unit to this because it's already grandfathered at X number of units, that you give up one of those units in the back to, if granted, this unit up front. So from the standpoint it's grandfather, it's allowed to remain so long as it doesn't become vacant more than 30 months in total. So if you had 5 units, you had 4, as long as you had somebody living in that structure for any period of time, your clock doesn't run, your 30-month clock doesn't start running.
So the property can be subdivided and another residence built in front of that, and that would still be.
Yes, well, basically what I'm saying is, for us, that as part of our enforcement, we would make them eliminate one of the units in that structure to get the unit up front.
For a maximum of how many units back there? 2?
So we end up in total on the lot, we don't exceed what they're grandfathered in. That's still something we're still after in our office, exactly how many units we have vested in that back piece. It predates zoning in Metro. So, I may not have a record that finds me, here's when it was turned into a residence. We do know from looking at some of our records when Metro was forming that it was shown on documents there, but they didn't list the number of units in that building. So we agree that they're vested in a boarding house type use. We need to nail down whatever number we've got. We're giving up one to get one in the front. So we maintain a balance on that site of not increasing the density or increasing the nonconformity.
Well, I think it's a typo. I should say 4-bedroom, not 4-unit.
Okay. Unless we have any other questions for the applicant, I would suggest we bring up the opposition. Any other questions? Okay. Position.
And as the lady comes forward, are there any other parties opposed to this case? Okay, miss, you'll have the 15 minutes there to your right-hand side.
This is a copy of the plan that was given out at the Christmas party that Ventures gave out to the community that I was able to receive after I left here. And I wanted y'all to see what the plan is. He said he didn't have a plan last time when I was here. I apologize. My name is Linda Tyler Goins, LINDATYLER-GOINS. I apologize. My husband couldn't be here. He's out of town. I got that from a resident who went to the Christmas party that Mr. Ventures attended. My concern when I came here was about the flooding and all that, because we got the notice about them setting the variance back. My next door neighbor, I talked to her. She had to be out of town. She told me she didn't get a notice, and she's 300 feet away from that boarding house. She's directly behind the boarding house, Penny Chadwell. On Jeans Court, there is a second-generation homes, and when I looked at the plan, I was like, well, what plan is this? The back of the parking lot, my stepchildren will be looking at the back of a parking lot in our house. He's planning on putting 15 homes up in there on a 2-lot. I don't know how that's going to improve the property value. And so I know that he's asking about the setback and he's did this, but I'm confused because I looked at the tape from our meeting last time. He said to y'all several times he didn't know what the plan was. That's clearly a plan. I mean, even though I know he's trying to do setbacks, that's clearly a plan. I think y'all asked him a couple of times, well, what's the plan? He kept on saying he didn't know. I feel like I've been lied to because he wasn't honest with me. And don't get me wrong, that may not have anything to do with this, but I'm concerned about the future of that 2-lot property.
Well, I think you heard the councilman say, I mean, your concerns are very valid. If I looked at that, I would be concerned as well. But I will say people get confused by metro zoning a lot. What this plan would require is action not by this board.
Oh, by another board.
It would require it by, well, it looks like two groups, probably the Planning Commission, and also I believe that's going to take a rezoning, I think. And so I think it's going to have to go through the councilman. And I think the councilman alluded to that.
Yeah, and the councilman, he just spoke to me today. I called him 2 weeks ago, and he said he apologized not getting back with me, but that didn't help. He could have talked to me prior to this, but he apologized for that. But I'm just saying, I called him 2 weeks after we left this meeting when he gave me that information, hoping that he would get back with me so I could dialogue with him about it, but he just met with me 2 seconds before we started. But
well, one, I sure don't want to diminish your concerns at all. I just want to assure you, if we granted it today, none of this would be allowed. I mean, they're before us on a very limited purpose today, and this plan would not come back before us at all. It would go to planning, and would probably go to council, then planning, then council. So anyway, if I were you, I would just give you the piece of advice to stay in contact with your councilman, and I can assure you this won't happen today.
Okay. That was my concern. Thank you.
Any other questions for the opposition? Have you got any other questions for us, ma'am? I'm sorry, if it wasn't for me getting that information last meeting, I don't think I would have had as much done. But thank you very much. The engineers have met with us and they're working with us now. Okay.
Thank you.
Well, thank you. Then I'm going to give.
I would like to ask you, based on what I think we're voting on today, are you comfortable with?
Mike.
Are you comfortable with us allowing that building to be moved forward?
I don't know why, he talks about it's such a, it's very interesting that he said that, because I decided to just drive around in different neighborhoods on McGavick, different places, and I don't see where that setback is so different from anything. And I talked to my husband about it because it's been that way for 50, 60 years. And I don't see where it's such an odd setback, is what he keeps on saying. And my husband and I, we drove around town because there's a lot of places in East Nashville that have odd setbacks. It's not that odd to me, but that's in my opinion, But if it's, whatever y'all decide is what decides. But I don't see where it's that odd of a setback. I didn't see where it was that special condition for that, because he's so concerned about that boarding house is all he seems to be concerned about, but he's trying to get that setback, but that boarding house is very important to him. So, but that's neither here nor there. So whatever y'all decide is what decides. But I don't see where it's that greatly setback as looking at Nashville, because if you go on McGavick, where my other house is, I have setbacks that's just like that. It is what it is.
I can help you just a little bit there, too. The way you calculate setback is by, and jump in when I'm wrong, Joey, which is probably likely, but you calculate it by measuring the setback of the other houses on the street for a certain distance. So that's why it throws it off so much.
But it's been thrown off for how many years?
No.
I mean, I'm not trying to be funny.
Let me make sure. I think what I hear you say is that the argument that we've been discussing before about the setback on the potential house on the same lot as the boarding house, that seems to make sense, and that it's unfairly calculated because the boarding house is there. But what I hear you tell us now is that the house that he'd like to move on that piece of property, your point is that that setback is normal to the neighborhood, and we should talk about the implications of what that means to move that house forward.
That's my thought.
Okay, that's what I heard you say. So okay, thank you.
Thank you.
And the applicant has a chance for rebuttal if he would like.
You want to start?
Go ahead.
I'm here before the board now to go through, as I laid out, the what my hardships are and the uniqueness to the setbacks. We did go to the Inglewood Homeowners Association and submitted that plan to get some feedback from them. But as Councilman or Commission, as Mr. Davis said, we're still in a preliminary. We haven't. I'm not in a position to say that's what's going to be there. I'd like to be able to have this layout now to be able to go forward on the property.
You'd like to have what layout?
I'd like to be able to have this approved now so I could have this by right.
So if there were to be a condition on that variance that said we would allow the variance on those two pieces of property to be 30 feet, provided that only 2 single-family homes were on each of those pieces of property, would that be acceptable? Because what you told us today is you're going to put one house on the left, front on both sides, one house in the back on the right, and you're going to keep the boarding house, which it says multifamily on our sheet, but you just said a minute ago it meant to be 4-bedroom.
Yeah.
A 4-bedroom house is a single-family house, so you have 2 single families on each lot. And if we all I'm saying is if we had that restriction on this variance, then it would prohibit you from doing the development that the opposition brought without coming back to us.
Yeah, Mr. Taylor, I'm not sure, zoning administrator and I, and John Michael, feel free to chime in. I'm not sure you guys have that kind of authority to restrict the possible development of it. It'd be almost
Well, no, I mean, just saying, all I'm saying is that it is, here's what I want to prevent. You tell me how we can do it if we do it, and I don't want to get into the debate part of it early, but, you know, we're being told that this is for 2 single-family homes per lot, and then we showed a plan that says, no, maybe it's going to be something different, and if we grant a 30-foot variance, we grant it for the property forever. And so... Well,
I think that's generally true unless someone rezone the property and they come up.
Yeah, I'm just asking for what conditions could we place on it, because I think the reason that we're hearing it for the second time is that that Dick King had said, you know, I think that we need to see what someone's actually going to do with the property. And what I'm starting to hear is a little bit that we don't really still know for sure 100% what you're going to do with the property.
Well, I'm not really sure what I'm going to do. I know I'm exploring all avenues, but I do know now that I'd like to move that existing house up to 30 feet, and I'd like to be able to build another house right next to it at 30 feet. And I'd like to have the flexibility of building another house behind that house that has an equal amount of easement area so their backyards are comparable to each other, and to deal with the drainage that the property slopes towards the back, and we're going to have to go through stormwater review to get this done, and they're going to give us some requirements. We're going to have to give them a drainage plan, just like it was if it was a regular subdivision development. It's going to be stringent, and I'd like to be able to use that back building as a 4 or 3-bedroom boarding house, and that's why I'm here today.
How did the other plan develop, and is it gone? Is it still something that you're thinking about doing, or is it completely off the table?
I have submitted it to planning, and planning is in support of it.
So it's it's still something that you're thinking about doing?
At some point in time, yes. I'm going to be perfectly candid with you. And they support the 30-foot setback.
I think that's what I'm saying to you is if you guys should consider this as it lays, and if he were to pursue a rezoning of the case, the variance essentially becomes moot at that point, because if he rezones it to a zone district, your actions would just essentially have no bearing on the future. It does. I'm not disagreeing. It does run with the land until such time that variance is sort of moot. And if he rezones it and designs it, or let's say Cahal goes all commercial, and it wouldn't have any bearing on those developments down the road.
This makes sense.
I guess I'm just a little troubled that at the last meeting we said we really would like to see what you have in mind for the property, and it took the opposition to tell us what you have in mind for the property, which you just said you actually do have in mind for the property because you submitted to the Planning Commission. So that's just a little troubling to me.
I can understand that you getting that impression, but as it is right now, I don't have the money to develop it that way. So at some point, maybe I would do it, but right now I'd like to put the two. I mean, and I know financial considerations have nothing to do with anything, but I'd like to be able to build the two for houses up in the front.
But didn't you just say that you didn't know for sure that's what you're going to do?
I know I'm going to build two houses up in the front like that. I do know that.
How about your appeal is based on moving them forward so you can add the house in the back?
Well, I'm going to move one up. I'm sorry. I'm going to move one up, and I'm going to build another one. I'm going to move that one up, and I'm going to build another one. I know that for sure.
You're going to build another one. You're going to move it up so you can build another behind it? That's my question.
I want to be able to build another one up behind it in the future, if that's the way it goes.
Yeah, the house, the block house in the back, he wants to be able to tear it down and at some point in the future be able to rebuild that unit.
Joey, I'm going to try and synthesize this. These are lots that allow duplexes, correct?
Yes.
Okay. So he has, by right now, the ability to build two houses. If we granted, and I'm not saying we would, but his variance request today, that plan we saw, he could not do without getting it rezoned, correct?
Correct. The density that's on that plan has to have a rezoning.
Right. And so if they were going to rezone it, it'd have to go through the council and the planning commission and all of that, and not us. And so, okay.
And that's not a guaranteed scenario, right? We're giving him the right to be able to develop this as it's shown.
Yes.
But the rezoning is not a guarantee.
Right, and really should not be a consideration for you guys at all.
Okay.
A side note, the back home can be demolished and reconstructed now without this board's approval. Okay. There are not any setback issues with that house at all. It's plenty far from the property lines. It's plenty far from the rear. Now, from the gentleman's point of view, it may affect where he needs to move this home to make that happen. Mm-hmm. That's something else, but it's not something he doesn't have to come to this board to ask to take that back structure here that I'm showing you down.
So really, the only thing before us are these two setbacks.
That's right. These two setbacks, and really the boarding house, the use aspect of that is not really before you. It's grandfathered. We're all in agreement of that. We're just going to make sure that if he's approved today, one of these rooming units has to go. So we stay with the same density on the lot.
If I may, if I was to demolish, or when I demolish that back house, I will have to go through stormwater review, and then I'll be back in front of y'all again, because it will be a hardship, because to try to get the water off, keep it from running it to that ditch, I'll have to ask, I think.
To kind of correct you would not be for this board, you'd be for the stormwater.
Oh, okay.
Yeah, it wouldn't be the Board of Zoning Appeals. So.
Do we have any other questions for the applicant? Okay, then I'm going to move to close the public hearing and open debate.
Joey, I have a question. The four houses that are to the left on the same side of the street, the five houses, do you know about what that average is of setback?
I looked at it briefly. They average anywhere between 34 to 38. There are sporadic, on the south side of Cahal, there are some that are much closer than 30 feet, these here. On that same side of the street, I believe this one sits about 38. This one's a little bit closer, and then this one drops back, and then again, 2 houses down is a little bit closer. You see it staggers a little bit through there. Across the street, they're clearly closer than 30 feet there in that block face. If you I wish our zoning code, it has been something I've advocated that we take more of a block average to determine this rather than just the 2 adjoining lots, because those lots in the middle of that block may be completely different than the houses further down. I've kind of advocated over time, and I hope the council sometimes reviews, but we would basically, in my future, if I were playing this, that between Scott and the next intersection, you'd kind of average that entire block to come up with an average.
That makes sense. I just have a lot of thoughts, and I'm trying to put them together. My initial thought is that and Joey, I can't see well enough to see what property number the one on the left is, the one with the boarding house.
That's parcel 267.
Okay, and I don't know what in terms of our cases, I'm not sure which street number that is.
This would be case 12, the one with the boarding house on it.
Is that 1621?
Yes.
Anyway, the one with the boarding house, I see a hardship. I do think it's unusual that boarding house is at the very end. I think that does skew the calculations on that one lot. And my personal opinion is that I don't have a problem with on that lot, and really that lot only at this point, until there's further discussion, granting a variance, but I think 30 feet is very close, and the average is 34 to 38 on and the goal is to be in line with the rest of the street. I think it should probably be closer to 35. So personally, on that one lot, I don't have a problem with granting a variance to 35 feet. The property on the right, I'm not there yet.
Well, just the property on the right is the lot that is skewed by this structure at the rear. This parcel is driving this plus this divided by 2 is driving the middle setback.
Right, and all I'm saying is that if we grant the property on the left and it's recalculated and it means he can move his house up 5 feet, 10 feet, whatever, it can be determined that way. But I don't see a hardship necessarily on that lot. I do see one on the left, but I don't see a need for 30. If the goal is to be in line with the other houses, I don't see the 30-foot, the need for 30-foot, other than possible plans that we haven't been shown today.
I'm where I was before. I still don't see what I'm looking for here, and that's knowing what's going to happen there. Too many ifs here to suit me.
I guess I'm struggling a little bit because I've had the benefit of not getting emotionally attached to the first hearing as much about this as there was. And so I guess we have a neighborhood that is reflective, if you look at both sides of the street of that kind of distance. I see the issues with the trees as being an exceptional situation. I see the other house as having an exceptional situation due to the boarding house scenario, and the fact that he is also trying to get rid of the block house in the back, which I don't think ever hurts the property values for anyone to construct a better constructed home. I guess I sort of feel like you're really trying to better this neighborhood and preserve the trees and character of the neighborhood that's consistent with the 10 houses on both sides of the street immediately thereafter, and I appreciate where you're coming from, Joey. I know I can't really make that a part of my consideration, but it seems to me that he's got 2 very, very interesting situations going on due to this property and this house in the back. And the fact that he can already build another house on there is really inconsequential to my decision that this man has an opportunity to develop a piece of property that he owns with another property, so it doesn't matter. What he's asking for us today is for a setback that makes sense. And I guess that's kind of where I'm at. He can already build a second home, so that whatever he chooses to do with either the boarding house or the home, it's grandfathered and it's okay by the rest of zoning is irrelevant and not in our purview. I think the only thing that is a discussion about whether or not we see that there's an opportunity here to move the setback closer on the left-hand side and allow him to be able to meet what's kind of consistent across the rest of this block. And I just don't see that we should hinder the opportunity there. Am I?
Well, I think I may have agreed with you in what I said, but it may be in how we think it's going to be developed. And, you know, it feels to me that the 30-foot variance is rolling down a road toward the plan, the bigger master plan that we saw from the opposition, not the plan that we're presented today that has 2 single-family homes on each lot. And so if I only go with what I'm presented with today and take it at face value and say, well, no, this is exactly what we intend to do, then I'm kind of back with where I was, that I don't see 30 feet. I see 35 feet based on the neighboring lots, and that gives you that gives the applicant the opportunity to do exactly what he says he wants to do on this plan. If the goal really is the bigger master plan, then I think that should be brought to us. And I might be inclined to say, you know, I thought it was a nice looking plan if the neighborhood's for it, and it's something that the council person in the district can support. I really didn't initially have an opposition to that plan. My problem with it was that we asked last time to come back and tell us exactly what you want to do with the property, and I'm still getting a lot of different answers.
But the problem is, I don't think that's even your business at this point. I mean, I don't mean this in a rude way. I'm just saying at this point, we are looking at exactly what he's telling us he can do with the plan based on the current zoning. And until he's been... I'm sorry.
Did we close public hearing? Are we? Yeah. Okay, we're officially in the...
We're officially in debate.
Sorry, go ahead.
Okay, so when and I don't remember if I heard anybody ask him if he's willing to take a 35 versus a 30-foot feet. Did you ask him that in the last? I didn't hear that. Okay, so maybe that's a question for, I don't know. But I think I hear what you're saying, and I think we're always trying to make sure that there's an integrity response in what we're doing. This man does not know, has not been approved. It's irrelevant what any future plan looks like to date, because there's no guarantee that he's going to be allowed to achieve those things. Yeah. So I think all that we can look at is what is before us.
Yeah, I agree with you. What we've been asked to do and what we've publicized and told the neighbors about is the plan that's in front of us. And this boarding house on the rear is a very unusual structure. I've not seen something on this since I've been on the board, and I think with combination of that and the trees, I see the hardship. So I'm willing to support that.
On both pieces of property, or just the one?
No, on both. I think the boarding house has skewed the second piece, and then there's some trees that are still on the second one too.
Yeah, I mean, I guess that my only point is that if you do the left one, then you know you still can. I mean, you still can move the house on the right, and
yeah, but if the whole point of setbacks are consistency, and so it would be weird if
he's willing to move it, maybe even better.
But I don't see the setback on the property on the right as being a problem. If you look at the houses across the street, the house on the right lot is just as far back as the ones across the street. I mean, there's nothing on that one.
You know, it was brought up by the opposition about how there's here, there, everywhere over in East Nashville. I mean, part of the reason is really due to natural disasters over the years. There was a bad fire in 1916, 800 homes were lost, 2 big floods, 1926, 1937, tornado, 31, 98. I mean, so this area of town has suffered tremendously, and when people rebuilt, they just kind of rebuilt here and there. So unfortunately, because of all of that, it's not as consistent as some of the other parts of town. So we just have to deal with that.
If your whole question is over 5 feet, are you just saying on the left side property or both?
The only thing I feel like I'm willing to to go with right now is a variance on the left piece of property, because that's the only piece of property I feel like there's a hardship on. The one on the right, I don't see it. I think that if we fix the left, then the right will be, by definition, fixed, because it will be calculated differently. Right now, the property on the right, the variance required on the property on the right is dependent upon how we calculate the property with the boarding house. And if a house is built on the left-hand property that is 35 feet off the setback, then the one on the right can be moved to within the right average. So I just don't see a hardship on the property to the right. I do think that it is kind of by definition we're allowing exceptions to the rules. We're allowing. I forgot, one of the councilmen that when I got appointed said, your job is to let people kind of break the law. And it was a little dramatic in the way he said it, but we're letting people break the rules. And I think when we let people break the rules for the reasons that we're allowed to do so, I think that the neighbors and the people that live around it have a right to know why and what is intended there. And so I think that that's important to know the plan, and that's why it does disturb me. I do think he has a right to develop his property, and either plan I was presented with today is legit, but there's enough question in it to say, we're tying these pieces of property together so that they can be one big piece, and I don't think that's given what we've heard today. I'm not comfortable with doing that just yet.
But can I synthesize? Because what I hear is a wee bit of distrust because he didn't initially disclose maybe what his plan was. I also hear kind of a question as to what is the hardship again? I mean, because we worked very hard to kind of come up with the hardship. And I've heard two other board members say, well, it's kind of, it will help the neighborhood, which I actually maybe even argue and agree with. But I'm not sure that's how we get to base our decision. And so what I kind of hear in my mind as I'm sitting here is I hear a need for somebody to go get SP zoning so that this can all be fully debated at one time as opposed to piecemealing it. And I know we only have something here in front of us, but I hear distrust, and I hear it would be for the better, and I hear 5 minus 2 equals 3, and so
I don't disagree with that, Chris, but the way I looked at this is that we grant the variance on the right-hand side due to the boarding house and the requirements of the setback that came, no, the right-hand side, because it's sitting back because of the boarding house. Then you allow the man to take the left-hand side as a second motion on the variance, because then it's in consistency with what we just granted and the rest of the neighborhood.
Okay. I do. I'm doing math up here, and I'm seeing a motion.
I understand.
And I'm seeing. Well, anyway, I don't know what I'm seeing, but would somebody like to make a motion?
To be honest with you, what I'm hearing here is that we are basing a decision on facts that are not in evidence in this case. And so I don't know that we even have an opportunity to come with a motion.
Well, I mean, to be fair, I hear the distrust, and I fully understand our role is to only do the facts. But I will say, in the distrust category, we have really struggled around to find. I get that. And so if there was unanimity and a screaming good,
we'd make a motion.
We'd make a motion. But I don't hear this is just me. I don't hear a unified board, and I hear some thoughts. And I will say, it is two lots moving in junction. If I were still a councilman, I would look at this and kind of think SP zoning myself.
Yeah, but if you went the SP way, he might be able to submit this more ambitious plan. So if the people really would have been able to live with this, but not the big plan, almost the SP way, he gets even more in the.
SP can be any of this. SP can be what's before us today. SP can be, but
But I think we have to act on what's in front of us.
Agreed. And anybody who wants to make a motion, go get them.
I'm going to craft one if I can find the sheet. I'm going to move that we deny the request based on the failure to comply with MCL 1740.37.
All in favor?
Was it seconded?
Oh, good point. I'm sorry.
I'll second.
Okay, so we have a motion, we have a second. All in favor, say aye.
Aye.
Oh, let's raise hands.
All right, so we have two. Motion failed.
Okay, then I'm going to go ahead and make a motion that we approve based on the drainage issues, trees, and boarding house being unique. All in favor, say aye. You're right. I do need a second. Second. So got a motion, got a second. All in favor, say aye.
Aye.
Okay. Fails for lack to get 4.
No, not exactly. You have a tie vote. The vote stands 3-4, 2 against.
Stays on the agenda.
This will stay on the agenda for the next 30 days. Who do I not have here?
And then, of course, our 2 members who are not here.
Yes, the 2 members who are not
they
here
have
the option to participate and become eligible.
Which now, thanks to our Metro 3 friends, if they have their own YouTube channel, you can go and watch the last 12 meetings of the BZA and the Planning Commission and the Metro Council, and go to your Channel 3 on YouTube.
Yes.
Fine people.
As I discovered to my horror that I'm
you
out
could
there.
even tweet about it if you want.
Not you guys, I just speak for me. But where we stand is that the vote to grant with motion. Mr. Ewing, you seconded the motion, is that correct?
I did.
Okay. Mr. Harper, Miss Garrett are allowed to participate should they choose to. They have to watch this proceeding. They did participate in the first proceeding, so they're caught up to that point. They are then eligible to participate. If by their participation you reach 4 votes, your case is granted. If you do not reach 4 votes, and you'll actually stay on the agenda. I got to count the days, but you're on for the next 30, and it may be 2 meetings. It may just be the next meeting. I'll have to look at the calendar, but it is calendar days from today. And that's where the board stands with that. We'll enter an order accordingly in the record. And with that dispenses with this case before us today. And Mr. Chairman, I'll go ahead while
Could we please have a 5-minute recess?
The board will be recessed for 5 minutes. Thank you. Okay, ladies and gentlemen, we'll get back underway. The board is now back in session. The next case 2000. Before I begin, one announcement from the consent agenda. Make sure I have 4 members here. Yes. You recall there were some folks in the back that had some questions about case 16. Mr. Thompson's case was on consent. They have had a chance to speak during the last case and are agreeable to his request. This case was a non-conforming retail building that this board allowed to be there. I think previously it was a TV repair shop. It's been in that neighborhood for many decades. He is requesting to change it to personal care services. Mr. Weston recommended that we still also allow retail as well, so that would give him flexibility to either bring in a nail salon or a retail establishment, so we wouldn't have to come back every single time there's a tenant change and ask you guys. That's his recommended condition on this case. I discussed with the applicant. He's agreeable to that as well. Also, I spoke to the folks that had questions. They're agreeable to it as well. They'd rather this gentleman not have to come down here every time his tenant leaves and he gets a new tenant. So with that, is there any other opposition present on case 16? Mr. Chairman, seeing none, that is the recommended condition for retail and personal care services on this, and that's Mr. Whitson's motion. I need a second, please.
I'll second.
All right, Mr. King, your second. And all those in favor?
All in favor? Aye. Any opposed? Okay. Passes.
All right, Mr. Thompson, thanks for your patience. You've been approved. Be sure your tenant comes down and finishes up their permit with us on Monday. This will also allow you, should that tenant to leave, to also have a retail tenant there and not have to come back. All right, thanks for your patience. And with that, we'll call the next case 2013-3, West End Development Company, LLP, the appellant and owner of the property at 2304 West End Avenue. This is an item A appeal in the MULA zoning district in the UZO to replace the tri-panel billboard located on this that reads to the northeast and replace that with digital. Referred to the board under section 1740-180A. That is also, I'm sorry, the record doesn't reflect that, is also item D as well. It was advertised as such. Sorry for the typo there. This is a non-conforming billboard, so the use is also non-conforming. Under section 1740-180, items A and D. The applicants are present. Item A appeals are somewhat different. Normally the zoning administrator will go first. This time he had to step out for just a moment. I'm going to go ahead and show the photographs and things and get to that point. I may drag him back in here. The case will be essentially Coast Department will explain its denial of the permit. The zoning administrator gives his position, then we turn it over to the applicant. So there's really not a rebuttal per se. The appellant will have his full time in that. But let's get to the case record. Okay, the subject property is located on West End, just north of the Vanderbilt campus on West End Avenue. It is recently rezoned to MULA. There's between 23rd and 24th Avenues north. This is the shopping center, if you're familiar with driving out that way, where Office Depot is located. I believe it's the major tenant in this shopping center. There's a bank on the corner at 23rd and West End as you're heading west. The billboard in question sits approximately right here on the aerial photograph, and you'll see photographs submitted by the appellant showing that location. But again, this is an item A, wishing to convert this tri-panel static billboard as defined by the code to an LED billboard. Views along West End Avenue on my visit out there show the shopping center, which you see there, in views facing toward downtown. Then back inside the shopping center, and the billboard in question is which you see here, and the view from West End closer to the billboard. The applicant's requesting to replace this entire face with an LED sign. Is that correct, Mr. Henry? That's right. All right. On the opposite side of this face today, there is an LED panel, which you'll see in the applicant's testimony. I apologize, I didn't get a photograph of that. This panel here is an LED panel facing the incoming eastbound lanes. And views along West End, facing towards Centennial Park in the upper left, looking west, and then just to give you a physical location of the billboard on that. And that's the case record. We have it. The zoning administrator, I believe, has put before you a letter to the board. Yes, I just want to make sure if I do not reach him, that's okay. I'm going to go ahead and read into the record his letter, and then when he rejoins us, if he wishes to add anything to this testimony. It said, dear members of the board, while I do not disagree with the applicant's position, I'm precluded by a recent court decision from issuing the permit. Sincerely, William B. Herbert, 4th Zoning Administrator. With that, I'm going to turn it over now to Sean. I'll let you guys go first. We'll just flip the positions here, should the administrator.
Thank you, Mr. Hargis. Chairman Whitson, members of the Board of Zoning Appeals, my name is Sean Henry, 315 Dedrick Street. My law firm represents American Outdoor Advertising, LLC. They are the owner of the subject billboard. On my left is Marty Williamson. He's president of that company, and on my right is Jock Gibb. He's the vice president of Formetco, a company that manufactures manufactures billboards and has technical expertise here today. I'd like to point out that I did supply to the board a memorandum with various exhibits, including the affidavit of Mr. Williamson here. And so I'd like to start out with Mr. Williamson describing what it is they currently do on that billboard and what they propose to do. So, Marty.
Thank you, Sean. Members of the board, thank you very much for your time and consideration today. Just a brief statement, I guess, from my perspective as the sign owner. I'd like to take a moment just to focus on the fact that we're not asking for a change of use for this particular billboard location at this address. It, of course, has already been permitted for both digital on the one side and TriVision on the other. It's been actually changed 2 or 3 times since it was originally erected several years ago. American currently has 3 digital advertising faces on West End, including this one at 2304 West End Avenue. The demand for digital advertising on West End is very high. I guess I'd like to mention that we're a small independent company. We're competing with 2 of the largest companies in the country, publicly traded companies, and West End Avenue is probably our most important artery where we have billboard coverage. The demand for the digitals is high. In fact, in many cases, we've been 100% occupied. So we have 2 coming into town. There's one further out on West End next to Bricktop's restaurant over the Avenue Bank. So that's the first one coming in on the left. And then you get to this location where we have a digital on the back side of this board. And so that gives me 2 inbound locations and 1 outbound, because also over Avenue Bank there's another digital face that backs up the 1 inbound face. That one is continually occupied. And so in order for us to compete, we just feel like this is a very important location for us. It already has a digital on it, so we're not wanting to really, in my opinion, change anything. It's already there. It's not like it's a new sign we're wanting to put up and make it a digital. The other companies have dozens of LEDs in Nashville, and we have 3, 4. So it would be a tremendous help to my company. It's a very high demand situation, and we have a lot of advertisers that we would like to service and help them have visibility on West End, particularly to the outbound going home traffic. So again, thanks for your time. I think there's a couple of slides maybe that I should show you to help you better understand it. So this top picture shows on the left half of it has a wrapped vinyl message, and then the right half is the LED. And then on the bottom picture, which is what we're trying to achieve here, it shows where there's a TriVision backing up that LED on the other side, and then a vinyl on the other half of that entire 14 by 48 face. And then on this slide, we're showing basically when we convert to a digital, it's taking up that same 14 by 48 square footage area. And then this is just to show you the 3 types of advert. We have the vinyl billboards, which is what this one is, a vinyl wrap. That's what it would look like. The next slide shows a TriVision. If it were a 14 by 48 TriVision, that's what it would look like. And then a digital showing it using the same square footage, 14 by 48. So I think that's all the time I need to take, Sean.
Yeah, Mr. Chairman, I'd like to kind of come through our points as to why we believe the zoning administrator has erred and why we believe the American advertising company here deserves this permit. We understand from the letter from the zoning administrator that he's largely referring to a recent decision by Chancellor Bonnyman in the Corky's billboard case that this Board of Zoning Appeals decided in November of 2011 that the change or conversion of a TriVision to a digital billboard was permitted under state law as a non-conforming billboard. We believe that interpretation and that ruling that you made then is valid, remains valid, and we are asking you to adhere to that interpretation and that decision here today. Last November 24, 2012, this property became non-conforming. Prior to that, as you saw in these slides, this property was not only permitted to have a billboard, but it was also permitted to have a digital billboard. On September 24 of 2012, the zoning was changed from CS to mixed-use limited alternative district, no longer allowing a billboard, no longer allowing a digital billboard. So at that point in time, my client's non-conforming property rights under state law and under your Metro Code of Laws kicked into gear. Regarding the Corky's billboard, again, this board decided that it was okay to convert from TriVision to digital. Here we're converting or replacing the TriVision and a vinyl that's there today with a digital. So that's one distinction. And that case number was 2011-089. The Metro government sued you, the Board of Zoning Appeals, because of the decision you made in that case. Chancellor Bondyman overturned your decision on November 27th of 2012. 3 days later, the Tennessee Court of Appeals issued an opinion in Cheatham County versus Cheatham County Board of Zoning Appeals, in which similarly you had the government suing one of its own entities, one of its own subdivisions, its Board of Zoning Appeals. In that case, this was an opinion from Judge Cottrell where she said that a county cannot be aggrieved by a decision of its own Board of Zoning Appeals. Therefore, it lacked standing to sue. We believe, and certainly the attorneys for Lamar in that case similarly believe that the decision of Chancellor Bondyman in that prior case should be reversed. There's a hearing scheduled for March 1st in which that question is being raised, and we believe should be decided that it's improper for the government to sue one of its own entities, in this case the Board of Zoning Appeals. So for those reasons, procedurally and substantively, we find that case really should not have any bearing on your decision here today. And there's some factual distinctions that we have here before you today, and I'd like to go over those. We have some different facts, and we also have some different legal grounds from your prior decision. Importantly, and distinguishing this application from what you considered before in that Corky's billboard case, they were simply arguing that their use was protected and they ought to be able to change out the technology. We're focusing here on the non-conforming structure itself, not so much the use, and I think there was some consent by Metro attorneys in that case that they weren't there talking about use, even though that was the applicant's request. So there's 3 sections of your non-conforming code, in the zoning code, that all 3 of these begin with, for all uses not otherwise protected by TCA 137208, you are allowed to make alterations other than incidental alterations to a non-conforming structure as permitted by this Board of Zoning Appeals. Again, we're focusing on the structure itself. That's section 17.40.650, D as in dog. Section 1740.660, B as in boy, allows repairs and incidental or structural alterations to a non-conforming structure, provided there's no increase in the degree of non-conformity. Here, as you can see in one of these photos, we're actually taking 2 signs down and putting 1 back up in its place of the same size. So there's certainly no increase in the degree of nonconformity. In fact, we think by replacing the 2 with 1, we're bringing this structure into greater compliance with the zoning code. Thirdly, section 1740.680, as in boy, addresses nonconforming operational performance standards. I'm not certain why this wasn't raised in the prior case, but really what we're talking about here regarding LED technology is the lighting of the structure. And lighting is an operational performance standard, and it applies to every use, every piece of property, no matter what kind of light source is emanating from a piece of property. Every piece of property is capped at no more than 0.5 foot candles as measured to the boundary of a residential property or across a public street. And in this case, Mr. Gibb here has done an analysis on that, and he can show that this billboard will comply with those maximum lighting operational performance standards. And secondly, billboards have a particular measurement as to their brightness and surface illumination, which shall not exceed 200-foot Lamberts for a billboard having internal illumination. That's 1732-150, item B16. We comply with that provision as well. So what we're pointing out to you is that there's ambiguity in the Metro Code of Laws, in the Metro Zoning Code. On one hand, there's a provision that prohibits LED digital lighting in this district. On the other hand, you're allowed to have any type of lighting you want, so long as that lighting does not exceed the two provisions that I just read. So we think that ambiguity favors the applicant in this case. I've got a couple of cases that I'd like to run through, but before I do that, I'd like the expert here to just comment on the study that they've done at this location.
Yeah, thank you. We actually have done a survey, a study. Once again, I'm Jock Gibb. I'm with Formetco. We're a digital equipment supplier in Atlanta. And we have, your code states that you should be no more than 0.3 foot candles above ambient light, and the study will show that we are actually 0.1. So we fall well within the local regulations.
We'd like to offer that for the record, if we may.
So I'm available for questions afterwards, but I'm just here to testify that, yeah, we do fall within all your local lighting codes.
If I may, Mr. Chairman, I'd like to just touch on a few legal precepts as you consider this request here today. There's not been too many cases on billboards, and certainly none dealing with digital technology that we're aware of. But one case important here, and in particular that's applicable, is the Outdoor West of Tennessee versus City of Johnson City from 2000. In that case, the billboard advertising company sought to enlarge the size of 11 of their billboards or to change those billboards from single-faced to double-faced, so going from one side to the other side. And the Court of Appeals in that case allowed them to do that because they were able to show that they had a pre-existing non-conforming use which qualified for protection under 13.7208 state code. We certainly think that's applicable here. There's an Attorney General opinion from 2006. It's opinion number 06-125, where the Attorney General, in response to some questions about billboard protection, indicated that the billboard owner is permitted to expand operations and construct additional facilities which involve an actual continuance and expansion of the activities of the business that was occurring prior to the change in zoning. Again, AOA, my client here, was in operation before the zoning changed in September of 24 of 2012. In this case, AOA is expanding the way it operates by constructing additional or new facilities in the form of this digital technology. It's replacing non-digital with digital. Secondly, AOA's technology upgrade allows actual continuance and expansion of the advertising activities underway prior to the rezoning of this property. So those two are important provisions are the tenets of that section of 13.7208B C, item C, that allows those alterations to be made. I mentioned the ambiguity in our Metro zoning code regarding lighting. In the recent case last year, City of Jefferson City, our Supreme Court acknowledged that ambiguities in zoning ordinances that would restrict a property owner's free use of property are constructed in favor of the property owner's unrestricted use of the property. So, setting aside the argument that we have protection under state law, focus on the ambiguity that we've pointed out to you here today. If you find that there's ambiguity in this code, that ambiguity favors my client, the property owner, and the ability to do what they're asking to do. Finally, before you considered the prior case at Corky's, there was a similar case heard in front of our environmental court judge referee Jim Todd, and this goes back to 2009. And it was the same issue, the same issue of changing non-digital technology on a billboard to digital technology on a billboard. Referee Todd states as follows in his order. The court finds, as the proof indicates, that the location of the sign has not changed. The structure of the billboard has not changed. The face of the billboard has not changed in size. And the goal of advertising has not changed. The court concedes that the manner, frequency, and method of illustrating the advertising has changed. But the court does not find these changes to be fatal in light of TCA 13.7208. So we submit to you that on really two different legal arguments. Number one, we think the ambiguity in the existing code, and this Board of Zoning Appeals is charged with interpreting and reviewing the zoning code and issuing interpretations and rulings on it. We think the ambiguity here would side for the property owner. And secondly, state law, we believe, and the case law that's interpreted state law per billboards, as to billboards, would indicate to you that this particular application should be allowed to change the existing vinyl and the existing Tri-Vision to LED, particularly because there's already digital on the billboard. It already has digital. That concludes my comments. Thank you.
Mr. Henry, we haven't received a copy of the Cheatham County case. Could you tell us just a little bit more about that whole thing?
Sure. Let's see. I might need to dig it out.
That's okay.
The essence of that case, and this was a concurring opinion that I'm referring to by Judge Cottrell. The essence of that case dealt with a nonconforming protection. I believe it involved a mobile home. And the court was able to decide that the Board of Zoning Appeals, and I don't recall how they ruled on the mobile home issue, but ultimately the people who own the mobile home were allowed to keep their mobile home. But importantly, the concurring opinion by Judge Cottrell, which I read verbatim, was that it makes no sense, and she found this rather outrageous, that a governmental entity would sue itself by way of suing a department, or in this case, a board or a commission. And so it's a very important piece of ruling, judicial prudence, we think, and I think the zoning administrator would agree with that. The importance of that, and what Judge Cottrell was saying is, she didn't want anybody to interpret the caption of that case, Cheatham County versus Cheatham County Board of Zoning Appeals, as standing for the proposition that this was a proper thing to do. And so that's why she issued that concurring opinion.
And then also, I guess I'm just going to ask you to disagree with me if I mischaracterize this at all. This board has on multiple occasions actually ruled the same way we did in the Corky's case, that, a billboard use is a billboard use, notwithstanding the technology, and we ruled on that multiple times and had cases coming back and back and back, and we actually, in fact, I'm certain I'm the one who said it, that we wish we had received judicial guidance. And at this moment, Chancellor Bonneman overruled us in Corky's and found that we had ruled unlawfully, I guess, or inaccurately. And so even though that case is being appealed in multiple ways, at the moment, that's the standing on our case, correct?
I disagree with that. In my opinion, that case is not fully adjudicated. That decision is still up in the air. And until this hearing occurs on March 1st, and there's a final decision and a final order in this case, we don't have a final ruling on that case. That's my opinion. We do not have a fully adjudicated case in this instance on that issue.
Any other questions?
That's rather a sticky wicket.
Well,
I guess I'm more fascinated by two elements of this case, and so I think maybe it's worth talking more about. One is that you've already been allowed to install an LED on the flip side of the sign, right?
Correct.
So the fact that you've already been permitted and it's already been allowed, and it's the same argument, I find it almost egregious that consideration may be a problem here, okay? But the pre-existing non-conforming use argument is, I think, where that we really have a different contemplation, and you're going for the structural aspects, because that's not something that we have necessarily made it all about in the past. We've considered those as being an element of it, being a pre-existing non-conforming sign and use of the property and advertising. But I thought the structural argument was kind of interesting. So can you help me a little bit with that?
Yes. The section of our zoning code that deals with nonconformities really calls out, if I can recall correctly, 4 areas of nonconformity. One is nonconforming use, one is the other nonconforming structure, nonconforming operational performance standards, and nonconforming signs. So it's those 4. And each of those 4 are avenues by which an applicant can come before this Board of Zoning Appeals and seek permission to do what they want to do under those provisions. And under the nonconforming structure piece, and again, the structure is nonconforming because MULA zoning as of September 24 no longer allows it. The structure itself is really what we're talking about. And I think the legal department conceded that point even in your Corky's case. I believe, if I recall, Mr. Sloan was saying, we're not here saying they can no longer not advertise. We're not saying they can't advertise. The issue is how they advertise. What structural alterations or repairs or changes to the structure are we going to let them make in order to advertise? So it's the mechanics, it's in this case, digital method of advertising. And in my opinion, it's no different than an analog watch and a digital watch. It's still a watch, but there's different technology that's driving the time. And so what we're arguing here, different from the Corky's perspective, is, number one, we're already there. Digital is already on the board. That wasn't the case in your prior consideration. And secondly, for whatever reason, they were arguing more about use of the property. We're talking about the nonconforming structure and what we can do to a nonconforming structure. And under that section of your code, an applicant owner is allowed to make repairs and incidental or structural alterations to a nonconforming structure, provided there's no increase in the degree of nonconformity. And it's that provision, which was not at all before Chancellor Bodyman, not at all before this Board of Zoning Appeals, is why we are here.
Is there any opposition? Okay. Are there any other questions for the applicant?
I have one. So is existing digital on both sides of the sign?
One side.
It's on one. Digital is on
Coming
the
into
other side, so they're back to back on the same sign structure, same pole, just facing different directions.
Mr. Henry, are there any double-sided digital billboards in Nashville?
I don't know.
Oh, yes, I have one on West End Avenue, the one I was mentioning
The Avenue
earlier.
Bank sign?
Yes, next to brick tops.
That's
on top of
double-sided.
the building, one face in each direction.
Okay.
I guess I'm confused. So that, even though it's 2 sides, is that considered one sign? Each side is a separate sign, or what?
Well, I consider it one billboard structure with an advertising face in each direction. That's how our industry looks at billboards.
Ask our legal advisor on that. Can you guide me on that one?
Do I understand your question to be, are we talking about one sign versus 2?
Right.
I mean, at the heart of it, you're talking about one pole, which is kind of the real property standard that you wind up looking at. But as to the signs, I've seen it discussed both ways. And I'm sorry to not have a more pointed answer for you, but I've seen it discussed both ways. I think the description that the gentleman from the company gives is not invalid. It is 2 faces of the same advertising structure. But driving down West End Avenue one way and the other way, how do you view it? How about this? People describe it as being 2 distinct signs. You have 2 totally separate ads on the same full, I think we call them 14 by 48 size spaces. So again, we've seen them written both ways.
Okay, but in the grand scheme of things, excuse me if I ponder aloud here, because this is an incredibly complicated situation for all of us, because we've already voiced how we feel about this. And
should I close the public
hearing?
Oh,
are we? I'm sorry.
I'm sorry. Just want to make sure for records purposes, if the zoning administrator wishes to comment on this case.
I've issued a letter, and then I'll stand by.
Okay, we read your letter earlier, so
It's been read in the record.
thank you.
Thank you.
I think it states my position.
Very clearly. Thank you.
Okay, with that, unless there are any objections, I'm going to close the public hearing.
I'm going to try to walk through this very illogical pathway to get to where we are, why I'm a little stressed about the situation with the change in zoning, okay? Because I think that's why we are here, and is that there's a situation where we've already granted this this use. It's already in use, and it's been allowed to exist, and to contradict that basis on this particular piece of property, I don't feel like is outside of granting a new non-conforming use scenario, which would be applicable to the current course standing. I don't know that our legal counsel sees it that way, but it seems to me that we're not talking about going outside the purview of granting a new billboard. We've already granted this piece of property this use. So it would be, to me, somewhat contradictory. Is that the case?
That's not in dispute.
Okay, that's kind of where I'm at. Is
digital versus vinyl versus tri.
But that's what I'm saying is that if we're not, are we in a position? I kind of asking this question. I said, bear with me while I'm going through this mindset. I'm trying to get a little clarity, but we're sitting in a minefield, and are we in a position at this point to say we've already granted this? Why wouldn't this be completely applicable?
What this case also comes down to, since this is item A, we're trying to say if the zoning administrator was right or wrong, basically.
Well,
so that's our real question. John Michael, is that correct?
Whether the zoning administrator acted in error or arbitrarily.
That's why we're here, and that's what we're going to vote upon.
Sure, that's the heart of the item.
Not whether all this other stuff. We're going to say, was the zoning administrator correct?
Right, that's a good description of the standard that you're deciding upon.
So at the end of the day, that's what is ahead of us.
I understand that, but the contradiction within the zoning administrator's decision is where I'm trying to get the heart of the matter. Do you understand what I'm saying?
And in what way, the contradiction?
Why would this be before us as a deciding board if the preclusion wasn't in front of us under our purview? Does that make sense?
John Michael, can you answer that for us?
Ms. Jones, if I understand your question, and if I understood it, I think it's a good one. How can it come before you if a court's decision makes a decision for you?
Right.
The appellant is absolutely legally entitled to appeal the decision of the zoning administrator, even if a court had said all the way up the line to the Supreme Court had already said these decisions have to be made in this manner, this is the guideline, this is what you have to do. It doesn't mean that the appellant can't appeal. So they have the opportunity to come make their case, to lay out the case law, as Mr. Henry very capably did, to give sworn testimony from their witnesses, and appeal if they don't get a decision here that they like, and pursue a parallel track. A couple of notes to go with that with regard to the prior decisions in Chancery Court with regard to the case that this board previously decided involving the Corky's property. Mr. Henry stated correctly, you do not have a finally adjudicated case. It was a March 1st hearing coming up, I believe it is. However, it probably merits mention that even if that decision was rendered on March 1st, it doesn't mean it can't be appealed, whether by this party or by the other party. And so even then, you don't necessarily have a finally adjudicated case. Toward that end, what do you have before you? You have a decision from the chancellor. It's not the highest court in the land by any stretch of the imagination. However, it's certainly a higher authority than our honorable board that we're with here today. So toward that end, you do have a valid decision from the Chancery Court that has overturned your prior ruling on a not identical but similar case involving digital billboards. Hope I didn't talk too long and kind of go past the heart of what you were inquiring about.
Mr. Chairman?
Yes.
I'd just like to state this. I met with Mr. Henry and the applicants, and I, in fact, encouraged them to appeal my decision to this board.
Thank you. Okay.
Okay, but I mean, just one man's perspective. Earlier, on multiple occasions, we found that the Metro Zoning Code was, for lack of a better word, too aggressive and violated Tennessee state law. And so we upheld our decisions under a grandfathering clause under state law. We even went as far as to disagree with our own legal counsel. And by the way, I'm perfectly comfortable with all of those decisions. But now we've got a court's finding, not final, but in place, and we've got the zoning administrator essentially saying, I must honor that decision, and it's going to be hard for me to find that that is either in error or arbitrary. So in other words, I am sympathetic to the applicant's position. I actually, as a person, still agree with our original decisions, but we have a court's finding or ruling in front of us, and it's in place this moment. And we've also got the zoning administrators in front of us. And so anyway, I find that hard to go against at this point in my career. I mean, you know, on the BZA. But that's just one guy's opinion. I mean, it's just, I was okay with saying the zoning code went a little too far, and I was okay with disagreeing with our legal counsel.
You just don't like being sued, Chris.
No. I'm comfortable with those original decisions, but now we've got a judge and we've got the zoning administrator. That's a lot of people.
I don't know. I think the zoning administrator has given us a pretty clear perspective that that's not his belief in the way that this should be interpreted. So I think, you know, I think there's a moment that we're looking at two different perspectives here, and the fully adjudicated portion is what I think gives you a place to hang your hat if you need one.
Well, let me put it this way. I wouldn't mind if this applicant appealed our decision. I mean, that's fine by me. I mean, they can appeal our decision, and I would have zero problem with that because I'm not. Well, I mean, you know, but anyway. It's not that I mind being appealed.
I guess I struggle with the fact that we've already granted the use of one of these on the backside of the billboard, that we do have a non-conforming use that is applicable. But I understand it's about the decision.
I have a point of clarification for John Michael.
Thank you.
My esteemed colleague said that we already voted to approve one of these signs. This board didn't vote to approve that West End digital sign, did we?
I don't recall. You may be predating the time that I was with you actually during that.
Was it allowed under the zoning?
Forgive me.
It was allowed under the zoning.
Okay, but they didn't have to come here.
No, they did not.
Okay, I don't remember, like I said, the BZA having to approve that. That was my point.
So it was allowed under the zoning. So what we're saying is the zoning change.
Yes.
There's a point there.
I was in the dissenting group of Corkies, so I guess I didn't get technically overturned, but I feel that these cases are similar. I do. And, you know, to me, I agree with Chris, the ideal thing is that either courts or the legislature, you know, hopefully clear this up for us. Billboards are very common in our landscape, and to have these piecemeal come back to us one at a time and have to say yay or nay, one on West End, one on Hillsborough or wherever, you know, I'm not sure if this is the best route for even the owners of these companies to have this done, to decide whether to have digital or not. And as the digital technology gets better and cheaper, this is only going to become more of an issue.
I, too, was on the dissenting side on the other case, so I guess it was totally different. There was
it wasn't
the West End Avenue thing was permitted by code, right?
That's right.
So was Corky's at the time. I mean, it was there legally. It's just they were trying to change it.
No, the LED was allowed in the zoning in that district. It's just been changed to MUL.
Yeah. Oh, correct.
But that's not the case with Corky's. It was not zoned.
Right, for
that's
digital.
Correct. For digital. They're very different.
I mean, it was zoned.
We call it non-conforming use under protection of state grandfathering as a non-conforming use, not LEDs permitted in that zoning.
Right, but
these were actually permitted. The first one.
They were permitted. They're not permitted now.
No, because the zoning just changed. That's correct.
Right.
How long has that zoning been in place? Do you know? Oh, I'm sorry. Do you know? Since September
24th. But the same thing happened out at Courtney's. I mean, it was legal up until it wasn't. I mean, that one. I mean, there was nothing unlawful Well, I'm sorry. You're correct. Yeah, I take it back. Yes, I take it back.
We found it grandfathered under non-conforming use. Right. It was actually zoned allowed up till September.
Right. And so now they're saying under the non-conforming statute they can make it all LED. Okay.
That's why they're going from the structure aspect. I mean, this is a different case, a different application.
I have a question for Joey. Joey,
there was a previous
under our current code, why isn't this allowed?
LED signs under the prohibited code section, 1732-050, excuse me. Letter H says that LED message boards, including and digital display signs, are not permitted in the following districts, and it lists out this base zone district here in this case is one of those districts listed where it's not permitted except for time, temperature, and date signs.
So the banks and the drugstores are safe.
They are grandfathered.
I can tell you what time it is.
It was previously allowed on this side.
The LED portion on the inbound lanes is from our standpoint, grandfathered to H2, this section I just read. What the applicant came is wishing to change the outbound lanes to that as well, and we denied him that now that it's zoned this way, you cannot do it. You would have had to obtain your permit prior to the zoning change.
That's kind of why I'm arguing that this is not a same case as applicable under the court case necessarily, because this was already allowed on that pole. Why would not this be covered by grandfather non-conforming use?
But it was allowed on one side. Could they have pulled the permit? There was something that they couldn't get the permit easily on both sides, correct?
I can't really speak to that, David, on that end. I mean, from the standpoint of...
Because there was that Green Hills billboard that was just on one side, and I remember there was something about you couldn't really easily get it on.
I guess from the application side, this structure has LED on it, yes, concede that.
But one side, but not
one
both.
side, but you're not allowed, once this rezoning occurred, I can't stretch that LED and change the face. Expand, it's essentially you're expanding the LED portion to the to a large portion of this building, this billboard.
This wouldn't be inclusive of a grandfathering protection by the state code?
What we're saying, well, that's what Mr. Henry's arguing.
That's what Mr. Henry.
And that is Metro's argument.
I think the fact that it was already allowed within that zoning district, it's already existing on that pole. And now that they've changed it as of a couple of months, why wouldn't it be covered?
I think the portion that is currently LED is covered. I mean, nobody can go and take that away from them. But conversely, they can't, and I don't know the proper percentages, but they can't make the other 3/4 LED just because 1/4 is LED. I mean, nobody's trying to take the 1/4 away, but they can't expand it to make it a whole.
Why would they be protected under the grandfathering statute?
Well, because they're permitted to what they have today. They can't expand it.
Because that's at Corky's we said that essentially a billboard's a billboard, a billboard.
Well, that was the case in that particular case. I think this is different. This one already has one existing.
Well, I know, but they're still asking to expand it. I mean, nobody's trying to go take their LED away. But they can't.
And that's why although I forgot to put it on here, typo. That's the item D portion of this. We're saying they are legally non-conforming as to the LED that's on that structure today. They cannot expand it. We've adjudicated that in court that they can't expand it.
They can't expand it because they don't have it today.
Because that's essentially it. And that's the D side of this, is that they're wishing to take the square footage that they have LED and enlarge it. And so in our purview, that is an expansion, that is an enlargement. They are increasing the degree of nonconformity. And the reason I'm tethering my words, you have other cases on this agenda that are similar in nature, so I don't want to try not to preface that. You have one coming up. Let me give you an example, a real world example. We have a billboard located on Hillsborough Pike. It only has one face. It faces north. The billboard in question came to us wanting to put a face on the southern side of the pole, and we said, absolutely not. You are grandfathered to that area that you have today. You can't stick a second face on the backside We saw that as an enlargement of a non-conforming. Mr. Henry may, that's not before you, so I can discuss that. But that would be an argument, that someone could say that, no, they're vested in a billboard is a billboard. They can put 2 faces, 6 faces on it, whatever, as long as they're not increasing
And the property and the lease that they hold is for the activity of advertising.
Until such time a judge adjudicates different, that's Metro's position.
I am incredibly sympathetic to our applicant, and I have no shame whatsoever over our prior Corky's decision or any of the ones before that. And I was not in the dissenting group. But at this point, I am going to make a motion that we uphold the decision of the zoning administrator. In other words, uphold Mr. Herbert's decision and deny the applicant's item A.
I will second that.
Okay, so we've got a motion, we've got a second. All in favor? Aye. All opposed?
No.
Okay, this case is a tied vote, like the prior case, 3 votes to 1. Unlike the prior case, we only have 4 members hearing this case, so we will reset this case for the next available public hearing, March 21st. De novo case, meaning brand new case, we can't talk about and warn the parties here. In the last case, we said, no, it's a brand new case. So it's as though you have not heard it. Perhaps we'll have 7 members. Perhaps we'll have 4, but that case will be reset for March the 21st.
Thank you.
Next case before you is case 2013-15, the American National Red Cross. The applicant's present. As the gentleman comes to the table, this is an item A case. Bill, do you wish to speak? Or
Joey, before we get started, I would like to disclose that 15 years ago, during the tornado, I was on the board of this chapter of the Red Cross, actually, and it's been 15 years since I've been on the board, almost. I feel that I can hear this case, but like I said, 15 years ago, I was on the Nashville Red Cross board.
Is there any opposition from either? Metro has no qualms about you hearing this case. Do you have any problem with the gentleman participating in the case? No, sir. All right. Any parties present, opposed, refusing hearing? I've seen none. Let me go through. This is an item A. Typically, the zoning administrator will go first, and sir, I'll cover for him in this case. Let me show you the photographs and the issue that's before you today. You all are familiar with the Red Cross property. It's located at the intersection of 22nd Avenue North and Charlotte Pike. It is recently, as of September 24, 2012, been rezoned to MULA and MUGA. This, as you notice, the zoning boundary bisects the parcel here. The applicant's sign representative came to see us to obtain a sign permit to convert their sign that's currently a standard sign with a menu board, a reader board on it, and convert it to digital. We denied his permit based on the situation that although this current zoning does not permit LED billboards. You have before you a letter written by me that covers the history. I hope you have that. And if not, I can read that into the record. But essentially, our position was that for the American Red Cross to have been vested, be allowed to do an LED sign, they would have had to have obtained a permit prior to September 24th, 2012. They did not do so, and therefore they have no right to obtain such a permit. They appeal that decision before you today. As a department, that's our position. We don't really take one way or the other, but those are the facts, and that's our position, that we're precluded from issuing a permit based on that rezoning. So the appeal ensued. I do want to show some photographs. Unlike the prior case, I do have a couple ground shots and a rendering submitted by their sign applicant. The existing signage, I apologize, I don't have a very good straight-on shot. The sign is in the bottom left photograph, as you see here, and this is a heavily traveled road, so folks will be familiar. They have but one, actually have 2 ground signs on the subject property. One is the well-known symbol of the American Red Cross, here located near 22nd and Charlotte. The second sign, and that's the sign in question, is further up toward 23rd. That's this sign here. The rendering of the sign, and you guys, I can get you a cleaner copy of that. This is the existing sign there, and that's the proposed signage that they're proposing there. And then it views along Charlotte, adjoining properties that the state owns on the north side. I do have a shot there. Hopefully you can make that out in this photograph. A little better shot of the sign in question. If that's the case, regulars, we have it. Sir, I'll turn it over to you. That kind of concludes the zoning administrator, unless, sir, you'd like to add something to the my testimony. He has nothing to add. Then we'll turn it over to you.
Great. I'm Joel Sullivan. I'm the regional CEO for the American Red Cross at 2201 Charlotte Avenue. Chairman Whitson and board, I appreciate you hearing this case. I think you will find that this is a good cause and a needed asset to our community. It's a more efficient sign. As you see, we have put the black letters up. On the sign, the top of the sign is lit. The sign is lit as it is to show the American Red Cross at the top and the letters that we do put up there. I personally believe that signs with letters and stuff that are put up by hand are dangerous, become flying objects during a storm, and so that first is the safety issue that I have with it. We need to display multiple messages, because right now we put a sign up, it's not feasible or efficient or good use of the donor dollar to continually go outside and change the sign. So we thought the best solution was to put a digital sign in so that we could do different messagings. For instance, perhaps we could use it on the blood side. We need specifically O positive. When you say we need blood and you're thinking, well, they need all kinds of blood. But if it said O positive and you're O positive, it might drive you to come in and donate blood and save 3 lives possibly. We also have disaster messages and classes that we like to advertise, and that helps produce a better community, a more resilient community in disaster. We recognize that donors make our mission possible, and to make it possible, we would like to recognize them. So this allows us to do multiple messaging rather than one message over a period of weeks. More importantly, as we experienced during the flood, people needed emergency information. They needed to know where to go, what to do, and how to get there. In a disaster, things change by the minute, much less by the hour. And signs that are of manual labor that you have to hang, it's just not feasible to inform the community in a timely manner. We also use it for public safety and awareness, and make sure the community is aware of what's going on. So there are huge benefits to our community to make it more resilient, to make it better informed, and to make it better trained if we could put multiple messages up other than one message every month or so. So I respectfully request your approval, and thank you for your time.
Joey, I have a question.
Sure.
Under their property zoning, how many signs can they have up there? Do you know?
It is a function of the amount of street frontage that they have. I'm sorry, Mr. Hugh, I don't have the exact road frontage.
Is it safe to say more than one?
Yes.
Okay.
Oh, yeah, the code, and let me pull that up just for a moment.
I don't know how many people were around during the Donaldson YMCA case, but I voted for a digital sign for that institution for a couple reasons. A, given their frontage, they are allowed to have more than one sign, and they were kind of consolidating to one digital or LED sign. And number two, I felt that the Y was a kind of unique entity in that area, that they were more broad in their message and serving the community. And I've never heard before that a sign can save lives, Mr. Sullivan, but I guess in your case, that's probably true.
Yes.
We will probably not hear that in front of the Board of Zoning Appeals again. And to me, the last thing that is very compelling about this sign, whether I would say this for anybody's sign too, is it's not near residential. And, you know, we get complaints all the time about LED being near residential. People are familiar with this area near Charlotte. It's a very commercial, office, industrial area, and there's not residential anywhere near this, or maybe kind of across near the railroad tracks over there.
Mr. Gearing, if they had 500 feet of street frontage on Charlotte or greater, they could have 3. I'm not certain, just educated guess, that street frontage. I don't think they're quite 500. If that's between 400 $300 to $499, you can have 2 ground signs, which is what they currently have out there.
Are there any other questions for Mr. Sullivan? Okay, looks not. Are there any opposition? I would assume not. So I'm going to go ahead and move to close the public hearing and open discussion.
This is actually a message board as opposed to a billboard per se, right?
An LED sign. Okay. It's a ground sign, not a billboard.
I think it's for the good of the city and constituency, but I don't guess we base our votes on that, our decisions on that primarily, do we?
Well, I mean, you could talk about not being near residential areas and consolidation. That's what we did with the Donaldson Y case. It's basically they can put up some more signs if they want to, and this is a more efficient use of this streetscape. And it's hard to no matter how long I'll be on the BZA, I'll never hear someone in front of us saying their sign will save a life.
I have to say I don't necessarily agree with that. If you're talking about the use of Amber Alerts and FBI signs on the other billboards, they do save lives. But I will also say you have a very compelling argument, and everybody knows where I stand on this. But I think it's an incredibly interesting situation that our council has taken this position on this zoning, and I think this is exactly why this makes no sense to me that this zoning change has occurred, and I'm not sure what was behind this, but you all already know where I stand on this situation, but I definitely think it is an awesome opportunity for our community to have communication. We've been through some natural disasters in such recent times that it is hard to understand what's going on, especially in that area. You've got a lot happening down there, so I stand fully in support.
Well, yeah, I'm going to take my opportunity to get on my soapbox as well, because this is for the public good. There's no doubt about it. We would be a better city with this sign. And it's really hard to argue with the fact that LED is not allowed in this zoning, period, end of story. Yeah. I mean, that's hard for us to argue with. So the only thing I would say is the next time some council person wants to say to David, we're in here to break the law, one, that's just silly, because it doesn't understand zoning. I mean, we are part of the zoning code as much as they're as part of the zoning code. And then two, their broad laws are not always infallible. I mean, right. And so I'm really struggling coming up with an intellectual justification for this, but I'm not sure that I'm going to let that.
It makes the case we just discussed a moot point, but I just don't understand the rationale behind all of this, and I think that I hope that this is a great opportunity to get our council to pay attention to that there are reasons that these kinds of opportunities exist, and I don't know that we have another opportunity. Did you find something that helps us?
I cannot claim that I found something, but
would it fall under mitigating circumstances?
Our quality
please help us out here.
Our quality council to the right. Yes, 17.32.04, which is exempt signs A, within non-residential districts, signs that are displayed for the direction or convenience of the public, such as signs which identify entrances, exits, drive-through, windows, or signs of a similar nature. I'm going to throw in, we need blood donors, are exempted. So I'm going to make a motion that we find that the zoning administrator, I'm going to move that the board overturn the decision of the zoning administrator, period.
Second.
All in favor?
Aye.
Any opposed?
Mr. Chairman, would you have speaking as secretary, would you have a problem with me citing the section you just mentioned as the reason for your, thank you, appreciate it.
Congratulations.
Thank you. I appreciate your support.
Hey, thank you for what you do every day, Joel. Thank you.
Finally, the last case today, case 2013-4. The applicant and opposition both present. Both parties, both the appellant and opposition. You guys have sat here 3 hours now, so you see how it works. You do have 15 minutes. I'm speaking to the opposition currently. If you have multiple speakers, please divide it up before you come up. This case comes before you on appeal at 1023 Villa Place. The appellant is requesting a special exception in the R6 UZO district to allow the use of the existing home as a daycare home for 12 children. Referred to the board under section 1716-170. The appellant has alleged the board would have jurisdiction under section 1740-180C. Board members, you have received letters in opposition. I believe you also have a correspondence from the council member who is opposed to the case before you. We do also in the record have letters in support of a proposed daycare here. Let me go over first the subject property you see here on the west margin of Villa Place, just north of Tremont Street and east of 16th Avenue South in the Music Row area. The base zoning for this property is R6, which permits, by special exception, approval of this board, the use of the home as also a daycare home. Distinguished for some of the members present and folks watching, daycare homes are a use that, not like a center where it's a freestanding use, daycare home is a use that must be accessory to the home. So it must be a house first. The applicant must live here. This is not rental property that they move in and operate this business out of. So that's the major distinction between the two versus a center that can be open 24 hours a day, does not require the resident, the operator, to reside on the premises. This is looking at the subject property by aerial photograph. You see the subject property located here. The applicant's proposing the fenced area to the rear to be the playground area, as well as parking along the alley would be here. I do note in the applicant's letter discussing some parking out on the street for drop-off. None of those spaces out front can be counted by the zoning code. I think you made a reference in your submittal to us. So the 3 spaces essentially for the use must be on the property, and those are being ingressed from the alley that she shows on the plan. You'll see in the photographs too. Daycare homes have sort of a component, kind of a joined parking requirement. It has 2 for the principal use as a residence. Those can be on the street. There's not a law prohibiting that, but the 3 for this use must be on the property. This is looking at the subject property from Villa Place, facing west, looking at the subject site. The adjoining properties on the got those oriented strangely, but the bottom left photographed is the adjoining property to the south. This parcel here is the northern property, and then catty corner here are parcels across the street of the subject property. And then a view along the rear of the property, 3 spaces being provided along the alley, having egress using the alleyway. Linda, I didn't have a note here on traffic and parking. I believe you guys have received comment from them. Were they I believe they commented on the on the parking. They don't take an exception. They'll cover anything on the permitting process. Their standard language there. But this is view in the bottom right photograph from the alley facing directly into the rear yard. I did not, upon my visit, get a good shot of the playground area. The applicant did submit some photographs for that, and I'll turn that case over to the appellant this time. Ladies, if you would please identify yourselves. You do have 15 minutes. Be sure to save some of that time for rebuttal should you wish to have it, and I'll turn it over to you.
Special exception for the family daycare home at 1023 Villa Place. My name is Shabonda Crawford. I decided to actually open the daycare home. I was a hairstylist for over 17 years. I was involved in a car accident 3 years ago during pregnancy, having my 3-year-old son. It permitted me to not be able to, I lost 85% of clientele. So my business plummeted dramatically, and so I decided to do a daycare home so that I could actually teach my child, as well as to provide, services for other children in the area. I actually grew up in this area in the 12th District on Kirkwood. I actually attended daycare homes myself growing up, so I know the benefit that it can give a child for being in a smaller structured setting. I also attended Aiken Elementary. We later moved to Villa Place. My mother here is the owner. We've actually had the home since 1982. We have it's actually been the cornerstone where my mother has actually moved in the house, moved out of the house herself, as well as myself too. With that being said, we thought it would be an ideal place to actually bring a family daycare home to the established Edge Hill community, considering there are several businesses down the street that are in walking distance. We see several of the neighbors take advantage of walking to these businesses, and so we thought that it would be an overwhelming number of support from the neighbors, considering there were 9 babies that were born on the block within the last year. And so, I wanted to make sure that it was a clean, top-notch, quality, place that would provide the standards, that we would provide the standards for the community, and, also through Department of Human Services. So I wanted to make sure that this was a licensed facility and not just, me doing something out of the home. So we actually started this process back in June. I, did 8 hours of intake with the Department of Human Services, where Codes was also there, and we have actually were approved. I actually asked Codes, could we do a 12 plus daycare home in that particular home. Was assigned a caseworker and was very eager to approve me upon meeting the requirements of Metro Codes. Since then, we have met all of our requirements through Department of Human Services, pending. We still have to do an environmentalist final walkthrough. But fire, Metro Fire, State Safety, Sprinkler, Metro Water, they have all approved and signed off on this. This is the only thing that's lacking us, as to get the board to actually grant a special exception. In terms of the special remod in the home, we actually had to do handicap bathroom, as well as the only thing outside of the property would have to be an actual handicap accessible ramp on the property. And so let's see, I went through the process in terms of with the neighbors, sending out letters to within 300 feet radius that was provided through Codes. I had to have an open house where we had neighbors actually to attend so that they could have questions and concerns. This was actually held December the 21st, and you guys also have a letter where we sent that out. I had one couple out of 60 families show up. And I thought it would have been an overwhelming response where they would have actually come. The one couple that did show up, I believe it's Jason and Corey Harley. They were very pleased with the home setting. They actually inquired on rates for their toddler. They did ask about parking, and did not realize how much requirements that we had to go through to have this. They also said that they would not see it to be a problem, and that they thought more people in the neighborhood would want to attend to ask questions. So with that being said, I'm going to leave some of this for a rebuttal, but what is the actual opposition for the neighbors? The 3 main concerns were parking, traffic congestion, as well as encroachment. I am very sympathetic and aware of that. I am a part of this district in this historical community. The issue with the traffic, we have additional parking spaces in the back. That's something I have no issue with. If we have to have our parents actually park in the back, that's not an issue. In terms of traffic, that's already a situation. Villa Place, the Edge Hill community down the street with other businesses, they actually park their cars there and they walk and they get out and walk. Get out and go to those businesses. I have no control over that. The only thing that I could do is to assure the neighbors that, if we granted the special exception, I will make it mandatory that the parents park in the back. But I still should also be able to have 2 parking spaces outside of the home. And then the other one was encroachment, having something commercial in a residential area. The house would still look residential. I cannot put a sign there. Before even having the sign put in the area for zoning, no one knew we even have. I actually have 5 children or less in there, which is under unregulated law. So that means I wouldn't even have to go through zoning. But because I have to have doing the 12, then I have to go through zoning. No one would have known this. So now that, the letters were sent out, it seems to be a trickle effect where it was opposition from the beginning from a few neighbors. And I've done everything that I possibly can to meet with the neighbors concerning addressing their concerns. And so that's the main theme is traffic, parking, and encroachment. My intentions for this is only for 2 years. I am simply trying to provide quality care for children parents in the neighborhood, working parents in the neighborhood, that they could actually drop their children off and even walk up to the home and have a safe environment for their children to be at. With that being said, I feel that it would be a great added benefit for the community. I don't feel that this would be, to bring the value down of the home, and I feel that it would be a great benefit for the community and even for them to actually bring their children as well. So I'm going to leave some of that to my mother, who is the owner of the property.
Hi, I'm Gloria Merriman, Siobhan's mother, and I have owned the property since Gloria Merriman. I've owned the property since 1983 and been in and out of the neighborhood. I raised Shay and her brothers and my family there. And, like Shay said, we've done everything possibly to address the concerns with the neighbors, and I think they'll tell you that even though they're opposing it. We postponed the zoning hearing so that we could have she had the opening house, only the one family came. We postponed the hearing so that we could meet with them again. We met with, I think there were representatives of about 6 families and addressed the space issues, the parking, all of the, the property values. I own the property, so, I don't think by putting a home daycare there is going to bring that property down. I've not seen any evidence to show that would happen. So we're here to do whatever we need to do to address those issues, and we've done that. But we are asking the board to grant that special variance so that we can have a daycare and provide value to the community. And this is one of the parents here.
My name is Terry Lewis. Thank you for giving me the opportunity to come and speak with you. I am one of the parents. I live at 913 South Street, so I'm in the neighborhood, and I bring my son to this daycare center. And before I found out about this location, I was taking my son to my sister-in-law out in Antioch. And then when I found out about this location, I took him away from my sister-in-law and brought him to this location. So it's convenient for me. Like I said, I live at 913 South Street, so it's in the neighborhood for me. I enjoy it. It's clean, and hey, I like it.
Mm-hmm. And also, he's taking his time out I believe you're sheriff at, or in the sheriff's department, works for the sheriff's department. So I appreciate his time to come in support of this too. So.
Thank you very much. Do we have any questions?
We have a letter from Council Lady Gilmore, who represents your district, and she is in opposition to this. And citing her opposition, she says that a vast majority of the constituents in the immediate area appear to be against this request. And I've looked through these letters that we've gotten against this. I count 9 different letters from different individuals. 8 of them live on Villa Place. 7 of those 8 live in the immediate 1,000 block of your area. Why are all these people against it if this is a good idea?
Well, I can't actually speak for themselves in terms of why they're against it. A poll was actually emails were sent that I was not aware of opposition. And again, I have, done everything that I possibly can to address their issues. It seems to be that this was something that was done without my knowledge. There were Rachel Zellstreet, which is actually here today. She's actually the Edge Hill Community President. I actually asked her when we first, were looking at doing this, what do you think about having this here? And she told me that, she said that, I don't see it being a problem. Are you going to put a sign there? And I said, no, we can't do a sign. She said, well, what about parking? I said, well, we have additional parking in the back. And that was pretty much what the gist of the conversation was. In terms of compliance, I told her that we were going through Department of Human Services and that we had to meet all of the requirements that they asked for us to do. With that being said, even with the other neighbors that were in opposition, I was actually asked to postpone this with Councilman Lady Erica Gilmore. I actually called her weeks prior to our first hearing, which was January the 3rd. I got no call back. The first call back I got was when all of the neighbors were in opposition. And then I get a call and said, you're not going to be approved, so you probably need to postpone the hearing and really reach out more to the neighbors. So I did that after going through this whole process since early August. And so we actually met. Council Lady Erica Gilmore came to the actual property, as well as Miss Rachel, and we had a list of what their concerns were. And we put everything on the table, and they asked me to actually draw up a letter of understanding addressing the concerns. The poll that was actually taken from the neighbors was a poll that the consensus was traffic, parking, congestion, and encroachment. Some of those were spacing, like, neighbors just didn't know that, the bathroom had been updated for handicap, that we could provide childcare for 12 kids. Those were some of the things they just did not know. But instead of reaching out to me, and my policy is open policy. They have all been welcome to visit the property. They've all been welcome to, ask me any questions or concerns, and I've done that, as much as I can. And so I think this is, even with Council Lady Erica, she had no stance before until now, and I believe that, she's been working with them for the past year now, so I believe she has to stand her ground in terms of taking a stance on the opposition. So I do have support from neighbors that are in that area as well, who have small children there that live on that particular block as well, and I have those letters as well. And I hope that answers your question. Okay.
Any other questions? Okay, thank you. You've got 5 minutes and 15 seconds for rebuttal, and we'll listen to the opposition.
Mr. Chairman, as the opposition comes forward, and for the appellant too, as it relates to parking, I don't want members of the board to be confused, or any party here. The parking for this use must be from the alley. None of your parents could ever use out front. Now, you could park your own vehicles there. There's no law against that. But the use, and not just everybody here, the parents coming must use the alleyway and park on the property. So, thanks.
Wow, it's a long day. You guys do this all the time?
Every 2 weeks. Every 2 weeks.
Well, Dr. Hall, who was there for a while, and his wife and Nora, their 1-year-old daughter, had to leave. He's got to get to work. So, but I think that we're all on the same page. My name is Rachel Zylstra, and I am one of the leaders of the Edge Hill Village Neighborhood Association. I've lived in the neighborhood for about 7 years, and I have a 4-year-old son, and we love the neighborhood. We came to this neighborhood because of its proximity to the Edge Hill Village community, and we can walk to Hillsborough Village. It's a fantastic neighborhood. I am going to ask that you deny the request for a special exemption for a daycare home in the neighborhood, but I'm really not alone in this. You'll see, I thought we had 11 letters, but some may not have gotten to you guys in time, but including the one from Councilman Gilmore.
I didn't count that one.
Okay. So we're close then.
It counts, but it's different than the people that live on Villa Place.
Got it. Urban neighborhoods like ours and those of 12 South and Belmont Hillsborough area are squeezed on all sides. Traffic, congestion, parking, and encroachment are major, major issues in our neighborhoods and our communities. And finding a balance of the residents and the commercial needs is difficult, and yet it's really important that we do that. I'm really sympathetic to Ms. Crawford. I like her a lot. I think she's doing really good things for kids, but it's causing a major problem already, and she has 5 kids there. I'm going to skip a lot of that because I think what's more important is that we are a neighborhood of lots of young families. She said 9 boys were born. That's really true. There are close to 20. 7 years ago when I moved there, there was 1. I mean, so we're a budding family. And you would think that a daycare home would be a good match for us, but it's proven not to be. A home daycare in the heart of one of the biggest areas of Edge Hill Village would negatively impact the neighborhood. The daycare, even as it's operated now with just 5 children, is already having a significant negative impact. 2 weeks ago, in just one day, I witnessed a dirty diaper in the street. A mom double parked on the street dropping off because there is no parking. I mean, Ms. Crawford was right. People are already using our street, and we're working with the Edge Hill Village community to prevent that with some of their valet parking and things like that. But they're already using our street as a parking lot. So there's no parking on the street. Her parents are dropping off on the street, double parking at times. And then on that very same day, and this is what was so shocking to me, and in the beginning where I was a little bit indifferent about the situation, on that very same day, I saw a parent pick up a child and then just do this U-turn right into oncoming traffic. It's so busy right there. Our neighborhood association is working with traffic and parking to try to do some traffic calming measures, but it's dangerous, and I saw that all in one day. But I think one of the things that's also of issue to us is that if the family was living there and they had children, as Ms. Crawford does, I know, and I've met her lovely son, that if they were living there and wanted to open their home to other children, I'd be far more open to that. But the truth is, she doesn't live there. Her mother doesn't live there. And so it's not being used as a family daycare home. And in fact, because we never see anyone there, it feels like a daycare center to us. It feels like a commercial venue, encroachment into our neighborhood. And historically, I mean, people have fought about it long before us to try to keep that neighborhood residential. And I really feel that we need to honor that. And the way that it's set up now, it's not Ms. Crawford living in the home with her children and also bringing in other people. I don't dispute that her family owns the home, but that's not the way that it's being used now. And it's causing problems in our neighborhood. And it's not a good fit for us. Thank you.
Good afternoon. My name is Nanette Dupre. This is my husband, Jason. We live at 1024 Villa Place, which is diagonally across. We have the same concerns as Ms. Solstrach has now voiced. Traffic, safety, as far as people doing U-turns. We live right across, and I have a big, beautiful porch, so I'm always outside, and I see very little activity in the evening, which tells me that there is not a permanent resident there. We bought our home just over a year ago, and if we were aware of the situation, I think we may have strongly reconsidered buying the home, even though we do love the neighborhood, and we like urban living, and that's why we live there. As far as the concerns with the commercial properties just further down the road, yes, they are there, but they're grouped, they're zoned to be there. And we are working with them to try and improve the issues with regards to traffic and so forth. One of the things that have been a great help is we had issues with people walking across the road because there was no zebra crossing, and those are all issues that we've improved and we hope to continue with. As far as the open house, yes, we did not attend. Reasons we did not attend was I was actually out of country. I am foreign. We have a very diverse neighborhood. We have people from all over the U.S. Ms. Silstra's husband, he's from Holland. So the timing was just really bad. We would have liked to. I actually got back from over a 3-week holiday to receive the letter with no knowledge of it prior to that. So I do apologize for not attending, and we do appreciate her being willing to postpone the appeal so that we could all voice our opinion. Thank you for your time.
And lastly, may I go again? Okay. Lastly, I do have a letter, and I don't know if it's part of it, but Ms. Crawford mentioned Jason and Corey Harkey as the one family that did show up for the open house, and they have also submitted a letter of opposition, and I have a copy here that I'm happy to provide. I don't know if they made the deadline. She is an attorney here in the government, metro government, but I don't know if she made that deadline.
Any other further questions? Okay, rebuttal.
I don't have that particular letter, so.
Okay.
That's a pretty strong accusation. Why don't you think they live there?
Well, because Ms. Crawford told me that she doesn't live there.
Okay.
I mean, I do believe that there is a brother. That one, I toured the facility with Ms. Gilmore, and one of the rooms appears to be set aside that's not part of the daycare home. But we are an active neighborhood. We're outside all the time. Our neighbors are meeting in the streets, and well, not in the streets, but on the sidewalk, talking a lot. And we've never seen a brother or a car that doesn't belong to our neighborhood in the facility. And I do know that there are these parking spots in the back, but they're just frankly not being used. The street is being used with just the 5 students, and frankly, students, I'm a teacher, with just the 5 kids, and frankly, the idea of going to 12 plus 3 would triple the amount of traffic and congestion, and it's frightening to us, and I really request that you deny, even though, like I said, I am really sympathetic to the work that she's done as an educator and as a mom. I'm really, really sympathetic to the work that she's done.
Rebuttal. This is your chance.
Okay. Addressing that issue in terms of, I really didn't want to actually put my personal business out, but I went through a separation, and I actually was living in the home when I decided to do the daycare. I was living in the home up until about a month ago. My brother actually is living in the home now because I actually got back with my husband, and so I actually ended up moving out of the home, and my brother actually stays in the home now. In terms of the traffic issue.
Oh, wait a minute. Are you going back to the home then to live in that home?
That would be open. I don't know yet.
And the reason,
but we're there. But we're actually there.
But do you? Oh, I'm sorry. Do you own? Are you the holder of the license?
Yes, I'm the holder of the license. Yes. But my mom is actually the owner of the property. And when I actually went through to the board, not to the board, but actual codes, it was from my understanding that the property had to be occupied. And it didn't have listed where the provider actually had to live in the home.
Joey, help us out about this daycare law.
I do. The license holder, this must be their residence.
Okay.
If your mother lives there and if she's the DHS license holder, but you could not hold a license and not live here.
Okay.
And,
there's no wiggle room in that. We can't deviate from that.
There is not. No, and that's evident. And I can't speak for the gentleman that does it now. When I used to give these talks with DHS, that's the very first. Well, this first thing I talk about. The second thing is you can't have dogs, but the license holder, this has to be their home. And must reside here because it's your home. That's the whole point of home daycare versus center. Center, you don't have to live there. I mean, that's something completely different. I think, and the concerns of the board and concern of myself is that question has to be answered before we really proceed much further.
Well, I think we should defer this. I mean, she said she's not living there right now, and so, clearly we...
And can I say one more thing?
Yeah, sure.
Before, that was not even an issue to begin with, in terms of when I met with the neighbors. It was mainly the whole traffic.
But that's not relevant for us right now.
Okay.
We cannot give you a license unless you live there and operate the daycare.
Okay.
That's not
and I was actually, there. So.
This is a special use of homes, and when they pass these laws, they want to make sure the person that's running this actually lives in the neighborhood. If you don't actually live in the house that you're operating this, you cannot get a permit from us to do this, period. Okay. We can't deviate.
We can't even discuss this for you at this point. Do we need to defer?
So what's the thought on deferment or deferral? 30 days, 60 days?
I think, what are our options?
She and
she can reapply, or we can give her 60 days to make a decision for herself, or?
Joey, I don't know.
I don't know, Joey.
Well, you have. Well, indefinite's not very wise. Well, if you defer, we're deferring on the merits of the case. Okay, right. But primary question one: are you residing here, or you intend to? If that's no, then there's not a case before you.
Yeah.
Now, if the mother does reside here and the license is in her name, she can apply.
Well, but she and her husband could move.
Yeah,
there.
she and her husband can move here. That's we would need evidence.
Maybe the question needs to be asked of her. Is that a consideration? Does she want us to defer it?
Would you like us to defer this for 60 days until you determine whether you want to live there?
Yes, that's fine. And let me get this clear. So the license holder, if they have to actually be the one to reside in the home.
Absolutely.
So.
David did a pretty good rendition. It's a home run business, so it has to be your home. So.
Right. And I was doing that at first, but yeah.
Well, congratulations on reconciling with your husband, but it may have changed your business plan a little bit. So you all need to have that discussion and tell us whether you'd like 60 days to make that determination.
Yes, that's fine.
Okay, so I'm going to make a motion that we defer this case for 60 days. Second. All in favor?
Aye.
Any opposed? Great. Deferred for 60 days.
With that, the Board of Zoning Appeals is adjourned for today. Thank y'all.